Weekly list, item number 24.
Alright, 24, my lord. Last time I submitted, they actually reached yesterday night 1 o'clock. They are already on the way to CWC. They are producing both the children, my lord. So let it be Monday so that I'll get it.
What was your last order?
କିଛି order ଆମର ସେଟା ଥିଲା ତାଙ୍କୁ CWC ପାଖରେ produce କରିବା ପାଇଁ IAC କୁ.
As such, our order was on 9-10.
9-10 is the last order, na?
ଆଜ୍ଞା।
ଦେଖିଲ 9-10 पर ଆଉ କିଛି ହେଇନି ତ?
9-10 my lord, last order.
Last.
My lord.
Plan Council for the state submitted that in the meantime, on completion of investigation, so charge sheet has been submitted. However, he has no instruction whether opposite party number 4 has been released on bail and he seeks some further time to obtain up-to-date instructions.
Mother file complaint
Which
in the
revealed
petition.
that opposite party number 4 has been released on anticipatory bail so and so. And he had never visited his village nor appeared before the PS at any point, is staying with some other place with his children without keeping in a relationship with others. Which for the two minor children of the petitioner could not be produced before the CWC for recording. That was in pursuant to the previous order. That
Yes,
means the order was passed on 25
Yes, my lord.
9/2020.
My lord. 25/9 is been also.
However, the family members so and so have been directed to intimate him to obtain. Read a copy. It is made clear as per order dated 11/9/2020 if the children are produced by their fathers before the Bolgod police station, the child welfare officer Khurda. So the first order was 11/9.
My lord.
Oh, that was a long order. Sure. Particularly when the minor children staying with the father and in absence of space also. They are not staying in the house of the in-laws. Some time to parent. In the meantime, on that last part of the order, in the meantime, child welfare officer Khurda shall visit the house of the opposite party number 4, meet the children of the petitioner and the opposite party number 4, and give a report about the status of the children by the next day.
But they are not there.
At that time, they were not there in the house of the opposite party number 4. They were placed somewhere else, in a secret place.
Yes, madam.
Now they have those two children.
Two children and father and the grandmother has been.
They have been tracked.
They have been tracked, and they have. But the effort is on to record the statements.
I have submitted report. Last, my lord, 6th line bottom, my lord. Today at 9/11/2023 at about 1 a.m.
9/11/2023 at about 1 a.m. I, along with my team, rescued the two minor children, so and so, along with their father Kesava Mudli and grandmother so and so. As per the order of this court, I produced both the rescued children before CWC Khurda for necessary action. However, I may kindly be allowed for another date producing the statement of the minor children recorded by the CWC Khurda along with the video recording of the so and so. So we just want to know that how they are being treated by the father
and
in whose company they want to stay, because the children's welfare is the paramount consideration. So whether their health, education, etc., were taken care of properly by the father or not, all those things, and moreover, in whose custody
they want
to now stay. Of course, the other side will have a visiting right.
Yes,
that's
sir,
a different
definitely.
matter. But in terms of our order dated 11/9/2023, where we directed the child welfare officer Khurda to visit the house of the opposite party number 4 and meet the children of the petitioner and the opposite party number 4 and give a report about the status of the child by the next date, comma. The IIC Bolgod police station today has submitted a written instruction wherein it is indicated that on the previous night, that is 8/9/11/2023, he along with his team rescued the two minor children along with their father and grandmother, and the children were produced before the CWC Khurda, and he has sought for some time to produce the statements of the two minor children recorded by CWC Khurda along with the video recording of the rescued children. The written instruction is taken on record. It is made clear that while interrogating the children, the CW cell specifically asked about their health condition, how they are being taken care of by the opposite party number 4 during their stay in his company, and more importantly, in whose custody they both of them are now interested to stay, and for what reason. The report along with the statement of the children shall be produced on the next date, which we fix to 13th November 2023. A free copy of the order be handed over to the Learning Council.
Can it be, it can be by 12 o'clock, I'll send it to the SADOC to.
कर देगी नहीं ऐसे wait कर दो आप. ପିଲାମାନଙ୍କୁ ତାଙ୍କୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇ ଦିଅନ୍ତୁ. ପିଲାମାନଙ୍କୁ ଯେତେବେଳେ ପଚାରିବେ ତାକୁ ଟିକେ କୁଲ ରିଫ୍ଲେକ୍ସନ ଅନ୍ୟାନ୍ୟ କଥା ପଚାରି, ନହେଲେ ସିଏ ତାଙ୍କୁ ସେ ବାପା ପ୍ରେସରାଇଜ କରିଥିବେ, ଟ୍ୟୁଟର କରିଥିବ, ସେ କହିବେ ତେଣୁ ସାଙ୍ଗେ ସାଙ୍ଗେ ରେକର୍ଡିଂ କରିବେନି. ଲେଟ୍ ଦେମ୍ ଟାଇଲ ଅନ୍ୟାନ୍ୟ ଜିନିଷ ପଚରା ପଚରି କରି ସ୍କୁଲ କଥା ପଚାରି ଇଏ କରି ସେ କରି ତାପରେ ଓଭର ଟେଲିଫୋନରେ ତାଙ୍କୁ କହିଦିଅନ୍ତୁ. ଫଟକିନ ପଚାରିଲା ମାନେ ସେ ଟ୍ୟୁଟର. Yes.
Item 50, madam, is ready.
କହିଥିଲୁ ତ ଆପଣ ରେଡି ହେଇଯିବ. ଦିଅ 50 ର ଫାଇଲ.
Item number 50.
Please use the mic properly.
The accused has been sentenced to undergo life imprisonment for murdering his own wife, my lord. The occurrence, my lord, took place on 13/10/2007, my lord. There is no motive, no quarrel, no premeditation, nothing, my lord. All of a sudden, on the afternoon, my lord, the appellant chased his wife and assaulted by Koturi. That is the
Please come to the FIR. Let us. FIR, it is at page 36 is the written FIR. So place that.
FIR, my lord. Mahasaya Ambe Sri Sardar Priya.
Sardar Tiriya is PW.
Sardar Kriya
One.
is PW1, my lord.
Yes. Continue.
ମୋର ବଡ ଭଉଣୀ ଦୁଗୁନିକୁ ଗତ 15 ବର୍ଷ ପୂର୍ବେ
Juguni is the deceased or what?
No, my lord.
Duguni deceased na nahi kon? Moro
Yes,
boda
my lord.
bhoni.
Duguni is the deceased, my lord.
That we are telling you. You said no. Yes. Moro boda bhoni Duguni.
ଜାତି ପ୍ରଥା ଅନୁସାରେ ବିବାହ
କଣ ମୁଁ ଛାଡି ଦେଇଗଲେ ନା କଣ? ମୋର ବଡ ଭଉଣୀ ଦୁଗୁନିକୁ
ଗତ 15 ବର୍ଷ ପୂର୍ବେ ଗୋଲମୁଣ୍ଡା ଗ୍ରାମର ରିବା ପୂର୍ତ୍ତି ସହିତ କମ୍ବି ନୀତି ଜାତି ପ୍ରଥା ଅନୁସାରେ ବିବାହ ଦେଇଥିଲୁ। ତାର ଗୋଟିଏ ପୁଅ ଜନ୍ମ ହେବାର ପ୍ରାୟ 1 ବର୍ଷ ପରେ ଭେଣେଇ ମରିଯିବାରୁ ମୋର ଭଉଣୀ ଦୁଗୁନି ତାର ଦିଅର ଟୁପାପୃତିକୁ ବିବାହ କରିଥିଲା।
ଟୁପାପୃତି is the
accused appellant.
Okay.
ତାଙ୍କ ଔରସରୁ ମଧ୍ୟରୁ 3ଟି ପିଲା ଜନ୍ମ ହେଇଛନ୍ତି। ସ୍ୱାମୀ ସ୍ତ୍ରୀ ପିଲାମାନଙ୍କ ସହିତ ଭଲରେ ଥିଲେ। ଆମ୍ଭର ଯିବା ଆସିବା ହୁଏ। ଆଜି 14/10 ସକାଳ ପ୍ରାୟ 8ଟା ବେଳେ ଗୋଲମୁଣ୍ଡ ଗ୍ରାମର ଚାମ୍ବରା ପିଙ୍ଗୁଆ ଆସି ଖବର ଦେଲେ ଗତକାଲି 13/10/2007 ତାରିଖ ଅପରାହ୍ନ ପ୍ରାୟ 2ଟା ବେଳେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଝଗଡା ହେବାରୁ ଟୁପାପୃତି ମୋ ଭଉଣୀକୁ କଟୁରୀରେ ତା ଘର ଅଗଣାରେ ହାଣି ଦେଇ କୁଆଡେ ପଳାଇ ଯାଇଛି। ଏ ଖବର ପାଇ ମୁଁ ଓ ଆମ
ଏଟା ଆଚ୍ଛା ଏଟା PW4 ଅଛି। ହଁ ପଳେଇ ଯାଇଛି। ତାପରେ
ଏ ଖବର ପାଇ ମୁଁ ଓ ଆମ ଗାଁର ଲୋକମାନେ ଘଟଣାସ୍ଥଳକୁ ଯାଇଥିଲୁ। ମୁଁ ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ଦେଖିଲି ମୋ ଭଉଣୀର ବେକ ଗାଲ ଓ କାନ୍ଧରେ ହଣା ହୋଇ ମରି ପଡି ଅଛି। ଆପଣଙ୍କୁ ଘଟଣାସ୍ଥଳରେ ପାଇ ଏହି ରିପୋର୍ଟ ଦେଲି। ଏହାର ତଦନ୍ତ କରାଯାଉ। Sardar Kriya, my lord, PW1.
So the charge was framed under 302 only.
Yes, my lord.
Okay. So and your defense plea is denial.
Yes, my lord.
Michha katha. So any eyewitnesses are there?
No, my lord. The eyewitness, my lord.
PW4.
PW4, my lord.
Let us come to that.
Only.
Let us see.
Submit, my lord.
No, place and then argue. Just PW4 evidence taku place karantu.
I know the informant Sardar Kriya, who is my cousin brother. I know the accused Tupapurti, who is standing in the deck.
In the dock.
He is my brother-in-law, husband of my cousin sister. The house of the accused
is close to my house.
Close to my house. This is Duguni, is my cousin sister.
Elder sister.
About 1 year back, at about 2 p.m., the accused Tupapurti committed the murder of his wife Duguni Purti in his house by means of a koturi. On the time of occurrence, I was suffering from fever and sitting on the outer veranda of my house with my breastfeeding daughter. In the meantime, I saw the accused was chasing his wife Duguni Purti from his house, assaulting her by means of a koturi, and she fell down in front of her house. And out of fear, I left the place with my child and went to the house of Tumba Hembram, who is my maternal uncle of our village. I narrated about the incident to my maternal uncle.
Tumba Hembram is PW5.
Yes, my lord.
Okay. Yes, cross-examination.
PW5, shall I please, my lord?
Read the cross-examination of PW4.
Cross-examination. My house is adjacent to the house of the accused. My husband was absent at the time of occurrence in our house. It is not a fact that there was a land dispute between my husband and the accused since last 2 years, and that I had no good terms with the accused. It is not a fact that the accused did not commit the murder of the deceased, and that due to land dispute with the accused, I am deposing falsehood against him. The accused mercilessly assaulted his wife Duguni inside his house first, and thereafter chasing her to again assaulted. Out of before outside of the house by means of a cautery, and in course of such assault, she fell down on the ground in front of her house. It is not a fact that due to enmity with the accused, I am deposing falsely.
Okay, PW5 ପାଖରେ ସେ ଯାଇକିନି narrate କରିଛି
Narrated,
ବୋଲି
yes, my
କହୁଛି.
lord.
You come to the evidence of PW5.
Yes, my lord. The informant Sardar Priya is my nephew, Bhanja. The accused Tupapurti, who is standing in the dock, is my Bhanji join. Deceased Duguni Purti is my niece, who got married to the accused. About 1 year, 1 month back, the accused committed the murder of his wife Duguni Purti by means of a cautery. While I was working in my paddy field, my niece Champa Pingua,
That is PW4.
yes, my lord, came to me and told that the accused had committed the murder of his wife Duguni Purti by means of a cautery in his house. On getting such intimate information, I came to the house of the accused, saw that the deceased was lying dead, and out of fear, I left the spot. Cross-examination, it is not a fact that there was no such occurrence and that I am deposing falsehood against the accused.
Okay, now who is the doctor who conducted post-mortem exam?
7.
Okay, please place the evidence.
On 15/10/2007, I was working as ONG specialist at SDH Karanjia and working as such till today. On the said date at 10 a.m. on police requisition, I conducted post-mortem examination over the dead body of the deceased, Duguni Purti, wife of Tupa Purti of village Golmunda, PS Jassipur, district Mayurbhanj, and found as follows. Rigor mortis was partially present over limbs. Both hands were clenched, and there was defense. Defecation. Lock. 3 post-mortem abrasion were found at place. Injuries. Thereafter, injuries. Incised wound 11/5/6 cm from left corner of mouth to left lateral side of neck, horizontal, and cutting underlying muscle
type of
and
blow
mandible.
दिया ଟିକେ ଦେଖନ୍ତୁ 6 cm ଭିତରକୁ ପଶିଛି. Yes, next.
Then incised wound 10/6/6 pm from just below and lateral to injury number 2 to back of neck, cutting underlying muscle and large vessel of neck on that side. Then, my lord, incised wound chopping out a flap of cheek with a portion of mandible size was 5/6 cm. Incised wound over left shoulder 11/6/6 centimeter, cutting muscles and upper end of humerus. Incised wound over back of neck of the level of 6 centimeter and 6 7 horizontal, and cutting verbal bones partially size was 11/6/7 cm. All the injuries were antemortem in nature, and the age of injuries was more than 24 hours and within 43 hours. Dissection. All the chambers of heart were empty. Time since death can be opined to be more than 24 hours and within 48 hours of postmortem examination. All the internal viscera like lungs, the liver, spleen, kidneys, stomach were intact. Stomach containing about 100 milliliters of food particles partially digested. In my opinion, the cause of death of the deceased is due to massive hemorrhage and shock caused by the above injuries, which were antemortem in nature. Blood sample of the deceased make in
Soaked in gauze.
handed over to the police in sealed glass vial. The death of the deceased is homicidal in nature. This is the said postmortem examination report of the deceased marked Exhibit 7, and this is my signature marked Exhibit 7/1 on Exhibit 7. On 14/10/2007, the IO made query to me and produced before me the weapon of offense, that is cutlery, with requisition to examine the and opine as to whether the cut injuries on backside, left side of cheek and left shoulder, etc. on the body of the deceased are possible by means of the said seized cutlery. Whether the seized weapon of offense is sufficient to cause death of a person in ordinary course of nature, and after examining the weapon of offense, that is cutlery, whose length is 68 cm, width is 4.5 cm, cutting portion is 22 cm. I opine that the injuries found on the body of the deceased are possible by means of the seized weapon of offense, that is cutlery. The seized weapon of offense, that is cutlery, is sufficient to cause death of a person in ordinary course of nature. This is my query opinion report marked Exhibit 8, and this is my signature marked Exhibit 8/1 on Exhibit 8. MO1 is the seized weapon of offense, cutlery, produced before me by the IO for my examination and opinion. The MO1 was kept in sealed cover packet along with other seized articles. The sealed packet is opened in the open court in presence of the learned additional PP and the learned SDC, and the same sealed packet is found intact. If somebody chased a person and assaulted him, the above injuries can be possible. Cross-examination by SDC. Postmortem abrasions on the backside of the deceased are possible by dragging of the body.
So we have you have placed the evidence of 4 witnesses. Who are the other witnesses?
Other witnesses,
What they have stated?
PW9 is
No,
IIC.
come serially. Let us see. Just shortly, we should because main witnesses you have placed. Who is PW1?
PW1 is, my lord, whosoever, my lord, examined, my lord, they are all related, my lord.
No, आगे place कर दियो तो तापर आपन submission करिवे. One टा कौन किए से?
One होची informant.
He the informant, okay. Just read it. That is page number 50.
Yes, my lord.
I
am the informant in this case. I know the accused Tupapurti, who is standing in the dock, is my brother-in-law. Deceased Dukunipurti is my elder sister. My elder sister Dukunipurti first got married to Devapurti. This Tupapurti's elder brother, she got married. When the elder brother of the accused, about 10 to 15 years back, and after the death of Devapurti, the accused got married to Duguni and remained as husband and wife. And out of their wedlock also, my lord, about one.
It's all right. That is, their children are there. Yes.
1 year back, the accused committed the murder of his wife Dugunipurti in his house at about
4 p.m.
4 p.m. At about 4 p.m. One
Chambara
Pingua of village Golmunda informed me about the death of my deceased sister on the next day morning of the occurrence. He's a hearsay witness.
Just read it.
Of the occurrence that the accused committed the murder of my deceased sister by means of a cutlery. On getting such information, I proceeded to the house of the accused, saw that my deceased sister was lying dead on the veranda of the house of the accused, and there was cut injuries on her neck and on other parts of her body. The accused was found absent in his house. Nani Hembram, Ramesh Hembram, and Madan Sinku of my village had accompanied with me to the house of the accused. I reported the incident in writing at Jashipur PS, which was scribed by
Manmohan Singh.
Madan
Madan
Sinku,
Mohan Singh.
as per my instructions. This is my said FIR marked Exhibit 1, and this is my signature marked Exhibit 1 by 1 on Exhibit 1. Police held inquest over the dead body of my deceased sister in the house of the accused and prepared the inquest report, and I gave my signature thereon. This is the said inquest report marked Exhibit 2, and this is my signature marked Exhibit 2 by 1 on Exhibit 2. Cross-examination. The accused has 3 sons in age group of between 5 to 6 years and 1 daughter aged about 2 to 3 years. It is not a fact that the age of the elder son of the accused is 12 years. When I reached in the house of the accused was found absent, and his sons and daughter were only present in the house. As per my instruction, Madan Singh scribed my FIR. It is not a fact that the accused did not commit the murder of my sister, and that I am deposing falsely in this case. Well, though the children were present, well, nobody
So
was.
PW4 intimated this PW1, right?
Yes, my lord.
About the occurrence, and accordingly he came, saw the deceased, and then went to the police station to lodge the FIR,
Yes.
and that was scribed by PW2.
Yes, my
That
lord.
is his evidence.
Yes,
And apart from that, he is also a witness to the inquest,
yes, my lord.
right?
Yes.
Okay. Now, at that time, the dead body was lying on the veranda of the house, and the accused or the appellant was found absent.
My lord.
Okay. Now you come to PW2.
PW4.
He, according to PW1,
Yes, my lord.
scribed the
Yes, my lord.
FIR,
I
right?
know the informant Sardar Tiria, who is my cousin brother. I know the accused Tupa Purti is standing in the dock, and he is my brother-in-law, husband of my cousin sister.
Yes.
The house of the accused is close to my house.
Court account purchanje.
Madan.
Madan to?
Deceased Duguni is my cousin elder sister. That 1 year back at about 2 p.m., the accused Tupapurti committed the murder of his wife Duguni.
PW2 you are pressing?
PW2 the.
Are you
4, my
pressing?
lord, 4.
No.
PW4 pura place kar sarlani puni kon PW.
PW2 yeah.
Come to PW2.
PW2.
Who's this
PW2 is my lord, scribe of FIR.
Right, just place. We just want to see that.
I know the informant Sardar Tidia. Similarly, I know the accused Tupapurti, who is standing in the dock, is the brother-in-law of the informant. 1 year back, Duguni Purti, the wife of the accused, expired in the house of the accused. I, along with the informant, Nandi Hembram, Ramesh Hembram, and other, had been to the house of the accused after the occurrence and saw there were injuries on deceased Duguni on her neck, and on other parts of her body, and the accused was found absent in the house. After some time, the accused came with the police to his house, and the accused confessed before us that he had committed the murder of his wife Dugunipurti by means of a katari and concealed the said katari under the bush of asana trees of village Chandraposi. As per the instruction of the informant, I had scribed the FIR about the occurrence, and this is my signature marked Exhibit 1 by 2 and the body of FIR Exhibit
On
by
the body of
1. On the body. Police held inquest over the dead body of the deceased in my presence in the house of the accused and prepared the inquest report, and I gave my signature thereon. Exhibit 2 is the said inquest report already marked, and this is my signature marked Exhibit 2 by 2 on Exhibit 2. Cross-examination. It is not a fact that the accused did not commit the murder of his wife Dugunipurti and that I am deposing falsely.
Okay, next PW3 place Column.
Yes, my lord. I know the informant Sardar Tidia. Similarly, I know the accused Tuppapurti, who is standing in the dock. He is the brother-in-law of the informant. About 1 year back, Dugunipurti, the wife of the accused, was murdered by her husband accused. I, along with the informant Nandi Hembram, Madan Sinku, and others, had been to the house of the accused after the occurrence and saw there were cut injuries on the neck, face, and on the other parts of the body of the deceased Dugunipurti. And the accused was found absent in his house. After some time, the accused came with the police to his house and he accused confessed his guilt before us that he had committed the murder of his wife Dugunipurti by means of a katari and also confessed that he had concealed the said katari under the bush of asana tree of village Chandraposi. He would show the same place of concealment if they would go with him, and so saying, he led the police and to us to the place of concealment, showed the place of concealment, brought out the weapon of offense, that is katari, from under a bush of asan tree of village Chandraposi, and the police recorded the said statement of the accused in separate sheet and seized the weapon of offense, that is katari, in my presence and prepared the seizure list, and after knowing the contents thereof, I put my signature thereon. This is the said statement of the accused recorded under section 27 of the Evidence Act, marked Exhibit 3, and this is my signature marked Exhibit 3 by 1 on Exhibit 3. This is the said seizure list marked Exhibit 4, and this is my signature marked Exhibit 4 by 1 on Exhibit 4. Police also seized blood-stained earth and sampler from the spot in my presence and prepared the seizure list, and I gave my signature thereon. This is the said seizure list marked Exhibit 5, and this is my signature marked Exhibit 5 by 1 on Exhibit 5. Police also seized the wearing apparels of the accused on his production at the PS and prepared the seizure list in my presence, where I gave my signature. This is the said seizure list marked Exhibit 6, and this is my signature marked Exhibit 6 by 1 on Exhibit 6. Cross-examination. It is not a fact that the accused did not confess his guilt before us. It is not a fact that the police did not seize any katari in my presence and also did not seize the blood-stained earth, sample earth at the spot in connection with this case. It is not a fact that the accused did not produce his wearing apparels before the police at the PS in connection with this case, and that I am deposing falsely.
Okay, 4 and 5 you have placed. Come to PW6.
Yes, my lord.
Page number
Yes,
63.
my lord. I know the informant Sardar Didia. Similarly, I know the accused Tupa Purti, who is standing in the dock. About 1 year and 1 month back, in a morning, I had been to the house of the accused and saw that Duguni Purti, the wife of the accused, was lying dead on there were cut, and there were cut injuries on her neck and on both the cheeks. The accused had committed the murder of his wife by means of a cutlery. Police held inquest over the dead body of the deceased Duguni Purti at the spot in my presence and prepared the inquest report and gave my LTI thereon.
So he is a witness to the inquest.
Yes, my lord.
Now, then 7 you have placed. Who is PW8? Constable. Okay, he is collected. Okay, leave it. Then 9 is the IO.
My lord.
IO.
Yes, my lord.
Okay, please place that.
Yes, my lord. On 14/10/2007, I was inspector in charge of Jashipur PS. On that said date at 8:10 a.m., I received information from one Vidyathara Mahanti, forest guard of Jashipur Wheat House, that he got one VHF message from Gudugudia Forest Rest House, communicated to me through constable number 830 Khogeshwar Patra, that one Tupapurti accused surrendered at Gurgudia outpost voluntarily after committing murder of his wife Duguni Purti. On 13/10/2007 afternoon, and I
Madam, just a second.
Just a minute.
My lord.
Just. Continue.
My lord. On 13/10/2007 afternoon, and I entered the said fact by the SD entry number 356 dated 14/10/2007 and proceeded to the spot. On perusal of Gudugudia OP SD entry number 173 dated 13/10/2007, I found regarding surrender of accused Tupa Purti. I examined Constable 862 Dhirendranath Sethi. On the same date at 9:30 a.m., I, along with other staff, proceeded to the spot, that is village Gulmunda, and the informant Sardar Tiria, son of Jattiya Tiria of village Kunarbila, PS Jashipur, district Mayurbhanj, presented a written report to me about the case at this spot. I treated the said report as FIR. and took a preliminary investigation. This is my endorsement with signature marked Exhibit 1/3 on the body of FIR Exhibit 1. I examined the informant and prepared the spot map. This is the said spot map marked Exhibit 10, and this is my signature marked Exhibit 10/1 on Exhibit 10. I took the photographs of the dead body of the deceased Duguni Purti and the scene of occurrence in my camera.
You are having no paper book?
My lord,
No.
My learned senior doesn't have all the deposition.
So why have you not supplied another paper book to madam? দিয়ন্তু দেখি পারনাতি কোন
Oh,
চাচ্ছি
bless my
কোর্টে Please, please.
yes, my lord.
Page
Come to
72.
page 70. Please, please.
My 72 I am reading, my lord.
Yes, yes, please, please. Continue. जोड़
On the
छाड़ी
same day,
हाँ
on the same day, at 2:30 p.m., I seized the blood-stained earth and sample earth at the spot in presence of witnesses and prepared the seizure list. Exhibit 5 is the said seizure list already marked, and this is my signature marked Exhibit 5/2 on Exhibit 5. MO2 is the said blood-stained earth and MO3 is the said sample earth. On the same date, at 4 p.m., I examined the accused Tuppapurti, seized his wearing apparels, that is pant, towel, and a scarf, woolen chadar, on his production at the spot in presence of witnesses and prepared the seizure list. Exhibit C6 is the said seizure list already marked, and this is my signature marked Exhibit 6/2 on Exhibit 6. MO4 is the said pant, MO5 is the said towel, MO6 is the said scarf, woolen chadar. On the said date at 4 p.m., I arrested the accused Tupapurti while he was in police custody, confessed before me and the witnesses that he has committed the murder of his wife Dogunipurti by means of a kotturi. He has concealed the same near a bush near village Golmunda. If they would go with him, he would show the place of concealment, and so saying, he led me and the witnesses to the place of concealment, showed the place of concealment to us, brought out the weapon of offense, that is kotturi, from the place of concealment underneath the bush and handed over the same to me. And I recorded the said statement of the accused under Section 27 of the Evidence Act in separate sheet. And I seized the said kotturi from the accused in the presence of the witnesses and prepared the seizure list. Exhibit 3 is the said statement of the accused, already marked, recorded by me under Section 27 of the Evidence Act, and this is my signature mark, Exhibit 3/2 on Exhibit 3. The accused gave his LTI on Exhibit 3. Exhibit 4 is the said seizure list already marked, in which the weapon of offense kotturi has been seized. And this is my signature marked Exhibit 4/2 on Exhibit 4. MO1 already marked is that said weapon of offense, that is kotturi.
Just a minute. Yes, yes, continue, please.
My lord, para 4, my lord. On the same day, that is 14/10/2007 at 4:30 p.m., I sent the dead body of the deceased through dead body challan being escorted by C830 Khageshwar Patra to SD Hospital, Karanchia for postmortem examination, and also sent requisition along with weapon of offense, that is Koturi, to MO SDS Karanchia for its examination and opinion as to whether the cut injury on backside neck, left side chin, left side cheek, and left shoulder are possible by means of the said Koturi, and whether the said seized weapon of offense is sufficient to cause the death of a person in ordinary course of nature. This is the said dead body challan marked Exhibit 11. This is the said query requisition marked Exhibit 8/2, and this is my signature marked Exhibit 8/3 on Exhibit 8/2. On the same day at 8 p.m., I returned to PS and registered the formal FIR by Jassipur PS case number 92 dated 14/10/2007 under section 302 IPC. This is the said formal FIR marked Exhibit 1/4 and continued investigation. On 15/10/2007 at 7:30 a.m., I sent accused Tupapurti to Jassipur CHC for his medical examination and treatment through Constable number 1027 Koruhari Machi. On the said date, I seized one vial containing sample blood of the accused being produced by C/1027 Koruhari Machi, along with his command certificate at PS in presence of witnesses, and prepared the seizure list. Exhibit 9 is the said seizure list already marked, and this is my signature marked Exhibit 9/2 on Exhibit 9. On the same day, I forwarded the accused to the court of SDJM Karanchia. On the same day at 5:10:20 p.m., I seized the wearing apparels, that is sari, blouse, saya, bangles, 3, one vial containing sample blood of the deceased being produced by C/830 Khageshwar Patra after her postmortem examination, along with his command certificate at the PS, in presence of the witnesses, and prepared the seizure list. This is the said seizure list marked Exhibit 12, and this is my signature marked Exhibit 12/1 on Exhibit 12. MO7 is the said sari, MO8 is the said blouse, MO9 is the said saya, MO10 is the said chudi, 3 bangles, and MO11 is the said vial containing sample blood of the deceased. On 3/10/2007, I made prayer to SDJM Karanchia to send the exhibits to RFSL Balasore for its examination and opinion. And this is the office copy of the said forwarding letter of SDJM Karanchia marked Exhibit 13. Exhibit 14 is the chemical examiner's report, and Exhibit 15 is the serological report of RFSL Balasore. On 8/11/2007, I received the postmortem report of the deceased from the MO of SDH Karanchia. After completion of investigation of the case, I submitted charge sheet against the accused Tupapurti. Cross-examination by defense. I have not examined Vidyadhara Mohanta in connection with this case. On 14/10/2007 at 4 p.m., I arrested accused Tupapurti in connection with this case. It is not a fact that I have not arrested accused Tupapurti while recording his statement under Section 27 of the Evidence Act. There is no fence around the house of the accused. The house of Champa Pingua is at a distance of about 100 feet away from this spot. It is not a fact that without proper investigation of the case, I have submitted charges against the accused.
So you have placed the entire evidence.
Yes, my lord.
Now we find, subject to what you say, there is a statement of an eyewitness to the occurrence. Here, just listen and then
My lord.
answer. She was sitting on the veranda of the house with her minor child and saw how the appellant chased the deceased holding a katari and mercilessly assaulted her and left. Then the next evidence comes is the corroborating evidence of the doctor who conducted postmortem examination. He has noticed number of injuries on the vital part of the body, more particularly on the neck area,
Neck, yes.
and further stated that it's a homicidal death. The cause of death was on account of these injuries, he has stated, and the weapon of offense was seized at your instance on the basis of your statement recorded under section 27 of the Evidence Act. That was sent to the concerned medical officer who conducted postmortem examination, and after examining the weapon of offense, he opined that the injuries caused to the deceased are possible by such weapon. Apart from that, it is sufficient in ordinary course of nature to cause death. Then the material comes that you surrendered in an outpost, and from that information was received by the IO, and then after that you of course taken into custody, and you gave the leading to discovery, and the manner in which the assault has taken place, even if you say just right while beginning the argument, you said that there is no motive, there is no quarrel, there is nothing, and this is the, but what we say that the law is that when the direct evidence is available, in a case of direct evidence, merely because the prosecution is unable to prove the motive, that cannot be a ground to disbelieve the prosecution case. Motive has significance in a case of circumstantial evidence. So, first of all, you make your submission as to why the eyewitness's version would be discarded or disbelieved by us.
My lord, all the eyewitnesses as well as other witnesses are also, my lord, same. They are all related.
Yes.
They are all related. But nobody has in their witness said that there was quarrel or
No.
there was
The houses of
both
these
wife and
people-
husband
the
has
the
not in
houses of these
good,
people are
not
in and
in
around.
good relation, and at least often also they were quarreling or they have some
Something might have taken place inside the house. Thereafter, the wife was running away, the accused chased him. So, if that thing has taken place inside the house, how the other person would know? The other person who was sitting can know what has happened in his front. That is, PW4 stated that I was sitting and I saw this. So, merely because he is unable to say about what has happened prior to that, so that doesn't disbelieve the evidence of PW4.
My argument is, they are all related. And ladies, no,
related means what?
adjacent.
Related to whom? Related to whom?
Deceased and accused both.
They are related to both.
They are related to both.
Why they would implicate somebody falsely and leaving the real culprit? It's a homicidal death. So the deceased was assaulted to death, and on the village road itself, while she was running away, she was chased and assaulted. So
village road, that was a time, daytime.
All
so
right,
many
all
people
right.
might have been
Is it your
gone
case
by that way, but nobody has
All
seen
right.
except
All
this
right.
PW4.
All right. Is it your case that a third party intervention could be there in such situation?
My lord,
Could
that
it
is
be there?
the house was on village road, my lord, and that is daytime.
That is how
Some
the houses are there. All
yes, my
corroborative
lord.
evidence
Yes,
by 2, 3, 4,
yes,
5. All have given the
yes,
corroborative
my lord.
evidence.
Only they are all related to that
They came
deceased
immediately
only,
to
my
spot.
lord.
Yes.
And even if, my lord, they are staying adjacent to their houses,
Mm.
even if some quarrel or some
No. It is
assault
happening
has
as
been
you
made
said.
between the husband and wife, my lord, that could have been come outside, my lord.
Oh.
But nobody has uttered a single word about that
ଆପଣ
husband wife quarrel
ଆପଣ
or
ଭୁଲି ଯାଉଛନ୍ତି
assault.
କୋଉ ସମୟରେ ଘଟଣାଟା ହେଇଛି। 2ଟା ବେଳେ ହୁଏତ କିଏ ଶୋଇଥିବ, ଖରା ବେଳେ 2ଟା ବେଳେ
ଆଜ୍ଞା, ହଁ।
ତାଙ୍କର ସ୍ୱାମୀ ସ୍ତ୍ରୀଙ୍କ ଭିତରେ ଘରେ କଣ ହେଇଥିବ, ତାପରେ ଜଣେ ବସିଥିଲା ବାରଣ୍ଡାରେ, ସିଏ ଦେଖିଲା
ସେ
ହଠାତ୍ ଇଏ ତାକୁ ଦୌଡଉଛି, ମାନେ ତା
ଦୌଡୁଛି,
ପଛରେ ଚେସ୍ କରୁଛି।
ସେ ଡରିକିରି
ହଁ।
ପଳେଇଛି ବୋଲି କହୁଛି।
ତେଣୁ ହଁ, ନାଇଁ ଦେଖି ସାରିଲା ପରେ ଯେହେତୁ ଆସଲ୍ଟଟା ହେଲା, ଓବିୟସଲି ସ୍ତ୍ରୀ ଲୋକଟା ଛୋଟ ଛୁଆଟା ଅଛି ତାକୁ ଧରିକିନି ବସିଛି, ତେଣୁ ସିଏ ପଳେଇଲା ଘର ଭିତରକୁ। ତାପରେ ସିଏ and see her conduct. She immediately went to PW5. This is Resgesti.
Yes.
He disclosed before PW5 that, and then PW5
Wow.
also came to the spot. PW5 went to PW1,
Yes.
and the informant
Say,
told him. PW1 along with others, including PW3, they came, found the dead body. Then the matter was reported. By that time, the accused went to the police station, surrendered, and the wearing apparels, etc., were seized. Then he was arrested, taken into custody, and then the seized, that weapon was seized at your instance. All these things are there. So this evidence, what has been adduced by the prosecution, how it was to be disbelieved.
All the witnesses are coherently corroborating each other. Coherently.
And more particularly that axe or koturi that was seized at your instance, the appellant, that was seized and it was found to be containing human blood.
Sure. My lord, but
ତା ଭିତରେ ନା କୋଉଠି
no
ଲୁଚେଇକିନି ରଖିଥିଲେ।
opinion. No opinion, my
Are
lord.
human blood, no opinion, it's all right, but human blood is there. କଟାରୀ କୁ ରିକଭରି କଲା ପରେ ଡାକ୍ତର ବାବୁଙ୍କ ପାଖକୁ ମଧ୍ୟ ପଠାଇଛନ୍ତି, ଡାକ୍ତର ବାବୁ ତାକୁ ଏକ୍ସାମିନ କଲେ, କହିଲେ ହଁ ଏଇ କଟାରୀ ଦ୍ଵାରା ଏଇ ସବୁ ହଁ ଗ୍ରୁପିଂ ମାନେ ଏ ଗ୍ରୁପ ବି ଗ୍ରୁପ ଏଇଟା ନାହିଁ, କୋଉ ହ୍ୟୁମାନ ବ୍ଲଡ ର ଯୋଉ ଗ୍ରୁପ ଗୁଡା ଥାଏ ସେତିକ ଇଏ ପାରିଲାନି, କିନ୍ତୁ ଅରିଜିନ ଟା ଡିଟେକ୍ଟ ହେଲା ଯେ ଇଟ୍ସ ଏ ହ୍ୟୁମାନ ଅରିଜିନ, ବଟ୍ what is the blood group that could not be detected, ascertained. All right. Yes, Mr. Misra, what do you say?
Lordship has already seen the version of PW4.
Hmm.
May I only, just to strengthen that argument that PW4 is to be believed completely, first of all, there is nothing in the cross that has come against the witness version, Your Lordship. If Your Lordship may take the spot map, that is at page 83.
Yes. Yes.
Lordship, here, number 3, item number 3 is the house of the
that eyewitness.
Eyewitness, yes. And Lordship may see this is the demarcation, but there are no boundaries.
Yes.
That the IO has clarified. This may be 100 feet apart, but there is no obstruction in between. So it is very clear that the witness has clearly seen the whole incident from the veranda of our own house, because the houses are facing each other as well, Your Lordship.
Adjacent.
Yes.
Now, my lords,
dead body was lying at this place.
That's the spot, Your Lordship, 1.
No, somebody has stated that when he came, the dead body was on the veranda. One witness perhaps has stated. But each jagare perhaps the assault se mane se IO kon kouchi dead body kood se dekhila asi pahunchila pare jodi inquest kala I entered the facts one show spot map prepared fully. Inquest over the dead body at the spot for the judge. Inquest reporter exhibit 2. Exhibit 2 টা দিয়ে বার করো। अरे एग्जिबिट लिस्ट हमारा हाँ इनक्वेस्ट ठीक अछि मुतापांकर घर अगणारे मरी पड़िथिबा पायागला से जो अगणा कहूची से अगणा रे तामन न से न बारंडार नुहे से बारंडार की उठे कहि देछि बट इट इज इन फैक्ट अगणा रे
फोर କହିଛି on the ground in front of her house.
Yes,
right there
that
that is
is
there
he has
that is
stated
there
that.
Exactly this spot.
spot map
Yes.
रे से यही indicate ହେଇଛି but someone has stated that on the baranda that was there but inquest report makes it very clear and inquest report ଲେଖା ହେଇଛି ମଧ୍ୟ ଆମେ ମୁତଫିଙ୍କୁ ସାକ୍ଷୀ ମାନଙ୍କର ଉପସ୍ଥିତିରେ ଓଲଟପାଲଟ କରି ଦେଖିବାରେ ତାଙ୍କର ପଛପଟ ବେକରେ 3 ଇଞ୍ଚ ଲମ୍ବାର ଏକ ଗଭୀର ଦାଗ ଥାଇ ତା ଉପରେ 4 ଇଞ୍ଚର ଗଭୀର କ୍ଷତ ଥାଇ ବାମ ପାଖ କାନ୍ଧରେ ପ୍ରାୟ 4 ଇଞ୍ଚର ସୁଆଁଶ ପିଠିରେ ସୁଆଁଶ ଥାଇ ମୂଳ ବାମ ପାଖ ପାଟି ପାଖରୁ କାନ ମୂଳ ପର୍ଯ୍ୟନ୍ତ 5 ଇଞ୍ଚର ଗଭୀର କ୍ଷତ ଅଣାଯାଇ ଥୋଡି ପାଖରୁ ପ୍ରାୟ 2 ଇଞ୍ଚ ଲମ୍ବର କ୍ଷତ ହୋଇ ହାଡ ଦେଖା ମାନେ ସେ ପିସ୍ ଟା କଟି ଯାଇଛି ପୁରା ଚପ୍ ଡାଉନ୍ ଦ୍ୟାଟ୍ ସୁଆଁଶ
ସେ ତ ଗୋଡଉଥିଲା ମାନେ ପଛପଟ ନେକ୍ ରେ କି ପିଠିରେ ମାଡ ହେଇଥାନ୍ତା ଆପଣ
no
ଫେସ୍ ରେ ବି
ମାନେ ସେ କଣ ରହିଥିବ ନା କଣ ଏଇ ପର୍ଯ୍ୟନ୍ତ ଯଦି ମୋମେଣ୍ଟ he assaulted my he might have torn so କଣ ପୋଜିସନ ଚେଞ୍ଜ ହେଇଥିବ nobody can say ଆଉ ସେ କଣ ଆଇ ୱିଟନେସ୍ ବସିକି ସେଠି ଲେଖିଥାନ୍ତା ନା କଣ ଖାତା କଲମ ଧରିକିନି ଇଏ ଗୋଟେ ମାଡ ଖାଇଲା ତାପରେ ବୁଲିଲା ତାପରେ ଏଠିକି ଏଇ ଜାଗାରେ ଠିକ ମାଡ ହେଲା ତାପରେ ପ୍ରଶ୍ନ ପଚରା ଯାଇନି ତାପରେ କୋଉଠିକି ମାଇଲେ ତାପରେ କଣ ହେଲା କିରେ ସିଏ ତ ଦେଖିଲା ସେ ଜଣେ ଲୋକ ମାରି ଚାଲିଛି ଇଏରେ ଆଉ କୋଉ ବ୍ଲୋ ଟା ଫାଷ୍ଟ ଦେଲା ଇଏ ଦେଲା so ଏଇ ଟାଇପ ର ପଚରା ଯାଏ ବହୁତ ସମୟରେ ଡିଫେନ୍ସ କାଉନସିଲ ମାନେ ବଟ୍ ହୋଲ ଜିନିଷ ହଉଛି the cross examination has nothing has been elicited so of course the problem is that it is the state defense council and but that he must have been somebody तार कौन experience
But
ଥିଲା
the evidence is very consistent.
consistent
Even if cross-examination would have come, we don't know.
Hmm.
But then the evidence is very consistent. A suspicion would have been raised for not having properly cross-examined. But since the evidence is
Yes,
so
ma'am.
consistent,
ଗୋଟେ କୁ ଆଉ ଗୋଟେ ଲିଙ୍କ କରିଦଉ କଣ୍ଡକ୍ଟ ପର୍ଟିକୁଲାର 4 ନମ୍ବର ଯାଉଛି ଘଟଣା ଦେଖିଲା 5 କୁ କହୁଛି 5 ଆସିଲା ଦେଖିଲା ଭେରିଫାଏ କଲା 1 ପାଖକୁ ଗଲା 1 3 ଘରିଆଙ୍କୁ ଧରିକିନି ସ୍ପଟ କୁ ଆସିଲା ଘଟଣା ପରେ ତାପରେ ଗଲା ଥାନାକୁ ତା ଭିତରେ ଇଏ ଯାଇକିନି ଅଲରେଡି ସରେଣ୍ଡର କରିସାରିଲାଣି ପୁରା ଲିଙ୍କ ରହିଯାଉଛି ପୁରା ଗୋଟେ ପରେ ଗୋଟେ ଆଉ ଏଠି ଆପଣଙ୍କର ଓନ୍ଲି ଯେ ଦିଟା ପଏଣ୍ଟ ଆପଣ କହୁଛନ୍ତି ଯେ କ୍ଲୋଜ ରିଲେଟିଭ ଗୋଟେ ଅଛି ଆଉ ଗୋଟେ ପଏଣ୍ଟ କହିଲେ ଯେ
କେବେ ବି ସେମାନେ ଝଗଡା ହଉଥିଲେ
नो
କି କଣ
मोटिव नो क्वारल एगुड़ाक किसी एस्टाब्लिश करनांती तेणु बाकी
ସେଦିନ ବି କାହିଁକି ଅଲ୍ ଅଫ୍ ଏ ସଡନ୍ ଏମିତି ହେଲା ସେ ବିଷୟରେ ବି ମାନେ
we
କିଛି
have to
ନାହିଁ
go by the evidence the witnesses are the eyes and ears of the court ତେଣୁ ସାକ୍ଷୀ ମାନେ ଯାହା କହିଲେ ସେ ସାକ୍ଷୀ ମାନଙ୍କର କଥା ବିଶ୍ୱାସ କରାଯିବ କି ନ କରାଯିବ ତାକୁ ହିଁ ତାରି ଉପରେ ଆମେ କେସ୍ ଟା ଡିସାଇଡ କରିବୁ ତେଣୁ ସାକ୍ଷୀ ମାନେ ଯଦି କହିଲେ ଆପଣ you remain unsuccessful in demolishing the version of the witness then obviously the thing is to be accepted ବର୍ତ୍ତମାନ ତାପରେ ଏ କେସ୍ ଗୋଟେ ଏମିତି କେସ୍ ନୁହେଁ ଯେ ଆପଣଙ୍କୁ ଏକ୍ସେପସନ ଭିତରକୁ ଆଣି ହବ ଯୋଉ ଏକ୍ସେପସନ 5ଟା ଏକ୍ସେପସନ ଅଛି 300 ଭିତରେ କିଛି ନାହିଁ କୌଣସି ଭିତରେ ଆପ୍ଲିକେବୁଲ ହଉନି particularly the manner of assault ତାପରେ କିଛି ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ନାହିଁ ଯେ କୌଣସି କଳି ଇଏ ସେ ଅନ୍ୟାନ୍ୟ କିଛି ନାହିଁ କି ଗ୍ରେଭ ସଡନ ପ୍ରୋଭୋକେସନ ହେଲା ସଡନ କ୍ୱାରଲ ହେଲା ବା ଅଣ୍ଡ୍ୟୁ ଆଡଭାଣ୍ଟେଜ ଆପଣ ନେଇନାହାନ୍ତି ଏଗୁଡା କିଛି ନାହିଁ ପୁରା ପୁରା କନସିଷ୍ଟେଣ୍ଟ ଏଭିଡେନ୍ସ ଦ୍ୟାଟ
Intensity
Well,
of crime not
continuously he is in custody from
Intensity,
last
no,
16 years, my lord.
that is a
That's
different matter that the state is to take into account. Say, semane kahaku se chhadibe no chhadibe. This that's a different matter. But
intensity of the blow was such.
6 सेंटीमीटर जदि भितर को पशिची भावंतु कोट फोर्स रे मरा हेतिबो दीटा इंजुरी नेक रो जो दीटा जाक अछि ना प्रत्येक इंजुरी 6 सीएम भितर को पसची 6 सीएम किछि कम नुहे हां सेट पे से काटिची मध्ये से वेसल्स गुडाक हां
the deceased even defecated. ମାନେ କେତେ horrifying.
ଦୌଡ଼ିକିରି ସେ ଚେସ୍ କରିଛି।
All right. JCR is number 22. Please take your seat. 22 of 2009. The appellant, Tuppa alias Tuppi Purti, faced trial in the Court of London Sessions Judge Mayurbhanj in ST case number 65 of 2008 for offence punishable under section 302 of the Indian Penal Code on the accusation that on 13/10/2007 at about 2 p.m. at village Golmund, he committed murder of his wife Duguni Purti, bracketary hereafter the deceased. The London Trial Court, by it in judgment and order dated 2/3/2009, found the appellant guilty of the offence charged and sentenced him to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000 in default to undergo RI for 6 months. The prosecution case, as per the first information report lodged by Sardar Tiriya, bracketary PW1, before the inspector in charge of Jassipur police station on 14/10/2007, is that is the younger brother of the deceased, and the deceased was given marriage to one Deba Purti of village Golamunda 15 years prior to the lodging of the FIR, and she was also blessed with a child. But 1 year after the marriage, since Deba Purti died, the deceased married to her brother-in-law, bracket husband's younger brother, Tupa Purti, bracket appellant. And out of their wedlock, 3 children were born. The husband and wife were living peacefully along with their children. It is further stated in the first information report that on 14/10/2007 at about 8 a.m., PW4 Chambara Pingua came to PW1, give information to him that on 13/10/2007 at about 2 p.m. there was quarrel between the appellant and the deceased, and the appellant assaulted the deceased with a cautery in his courtyard and had left for some unknown destination. Hearing such message from PW4, the informant PW1 along with other co-villagers came to the spot where they found the deceased was lying dead with injuries on his neck, cheek, and shoulder portion. On the basis of such written report of PW1, the IIC of Jasipur Police Station registered Jasipur PS case number 92 dated 14/10/2007 under section 302 of the Indian Penal Code against the appellant. IIC लिख दो PW9. The stop. Prior to the registration of the first information report, the PW9 received VHF message from Gurudia Forest Rest House that through Constable Khageshwar Patra that the that the appellant had surrendered at Gurudia outpost voluntarily after committing murder of his wife, deceased. PW9 entered the said fact in the station diary and proceeded to the spot and proceeded to Gurudia outpost where he found the appellant had surrendered. Gurugudia. Outpost. He, along with the other staff, proceeded to the spot, that is village Gulmund, at about 9:30 a.m. on 14/10/2007, where PW1 lodged the written report. PW9 examined the informant, prepared the spot map exhibit 10, took the photographs of the dead body and the scene of occurrence, held inquest over the dead body and prepared inquest report exhibit 2, seized the bloodstain earth and sample earth as per seizure list exhibit 5, stopped. He also examined the appellant, seized his wearing apparels as per seizure list exhibit 6, and at 4 p.m. arrested the appellant, and while in police custody, the appellant not only confessed his guilt but also stated that he had concealed the cautery near a bush in village Gulmund, and if the police party would accompany him, he would show the place of concealment, and so saying, he led the witnesses to the place of concealment, showed the place to them, brought out the weapon of offense, that is cautery, from the place of concealment, that is underneath the bush, and handed over the same to PW9. The PW9 not only recorded the statement of the appellant under Section 27 of the Evidence Act in separate sheet, but also prepared the seizure list after recovery of the cautery at the instance of the appellant, which has been marked as Exhibit 4. On the same day, at about 4:30 p.m., PW9 sent the dead body for post-mortem examination through constable to SD Hospital, Karanjia, and also sent the weapon of offense, that is cautery, to medical officer SDH Karanjia for its examination and opinion come as to whether the cut injury on the body of the deceased were possible by such weapon, and whether the seized weapon of offense is sufficient to cause death of the person in ordinary course of nature. Stop. The appellant was also sent for medical examination on 15/10/2007, and blood sample of the appellant was collected by the medical officer, which was seized, and then the appellant was forwarded to court of London SDGM Karanjia. The wearing apparels of the deceased after the post-mortem examination were produced by the constable, which were seized as per seizure list Exhibit 12. On 3/10/2007, PW9 made a prayer to SDGM Karanjia for sending the exhibits to RFSL Balasore for its examination and opinion. And accordingly, the same was sent, and chemical examiner report examination report by Exhibit 14 and serological report by Exhibit 15 were obtained. The IU also received the post-mortem examination report of the deceased, and on completion of investigation, he submitted charge sheet against the appellant under Section 302 of the Indian Penal Code. Next para, after submission of charge sheet, the case was committed to the Court of Session, complying the due procedure, where the London Trial Court framed charge against the appellant as aforesaid, and since the appellant refuted the charge and pleaded not guilty, the sessions trial procedure was resorted to prove his guilt. Stop. During course of a trial, the prosecution examined as many as 9 witnesses, state the witnesses in brief, and also proved 15 exhibits and the 11 material objects. Stop. The defense plea of the appellant is one of denial. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that the death of the deceased was homicidal in nature, and the injuries caused to the deceased are possible by the seized weapon of offense, which is sufficient to cause death of a person in ordinary course of nature. The London court also held that from the evidence of PW2 and PW3, it appeared that the appellant confessed his guilt voluntarily without any coercion and undue influence to have committed murder of his wife in the broad daylight, and as such, the extrajudicial confession made by the appellant before them was voluntarily and without any coercion. The London trial court also accepted the evidence relating to the recovery of the weapon of offense, that is Qatari, at the instance of the appellant. The eyewitness evidence was also accepted, and the London trial so also the evidence of the other witnesses, and the London trial court, on a close scrutiny of the oral and documentary evidence, held that there is clear, cogent, and convincing, unimpeachable, and satisfactory evidence adduced on behalf of the prosecution, which indicate that it is the appellant who intentionally and knowingly committed the murder of the deceased, who is no other than his wife, and accordingly found the appellant guilty under Section 302 of the Indian Penal Code. The C. Kasturi Land Council, appearing for the appellant, contended that the witnesses are closely related to the deceased, and therefore there is every chance of false implication of the appellant in the alleged crime. She highlighted that the prosecution has not established any motive behind the commission of crime, and there was no quarrel prior to the occurrence, and therefore there was no reason for the appellant chasing the deceased and assaulting her with the axe, Kotari. The Land Council for the petitioner further submitted that the appellant further argued that Mr. Misra, this observation which has been made that before two persons he made extrajudicial confession, where is that evidence?
That he is referring to PW 2 and 3.
2 and 3 asile outre mu se dekhiବାକୁ ଚାହୁଁଛି ଯେ PW 2, that is in the presence of the police, that they you after some time accused came with the police. So that was not that leading to discovery, say. So he has relied upon this piece of evidence also. So
Yes.
So that is that.
And PW3 has stated that he has signed. PW3 is the one who has signed on the Section 27 confession.
A part of that statement is admissible.
My lords.
so much of information which lead to the discovery of the weapon of offense. ମୁଁ ମାରିଲି ତାର past user, that is not admissible. ତେଣୁ ଏ ଯଦିଓ ଏ witness କହିଛନ୍ତି the that too in the presence of the police, that should not have been taken that extrajudicial confession. କାରଣ extrajudicial confession ର ଯୋଉ criteria ରହୁଛି section 24 ରେ, that is not here. ମାନେ voluntarily ଜଣେ ଯିବ ଜଣଙ୍କ ପାଖରେ without anything, but if it is made in the police custody, how can it be admissible? Only the information ମୁଁ ଦେଖେଇ ଦେବି ଚାଲନ୍ତୁ ଇଏ କରି, that thing is different. So submitted that the Learning Trial Court should not have held that the evidence of PW2 and PW3 relating to the extrajudicial confession made by the appellant before them was voluntary and without any coercion, particularly when it was made while he was in police custody. And accordingly, it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Shonok Mistral and counsel, on the other hand, argued that the witnesses are not only related to the deceased but also to the appellant, and there was no earthly reason for them to implicate the appellant falsely in the commission of murder of the deceased. He highlighted the evidence of PW4, the solitary eyewitness to the occurrence, was stated how the appellant chased the deceased and assaulted her with a cautery, for which she fell down in front of the house, which has not been shaken at all in the cross-examination. Referring to the spot map, the land counsel argued that the spot is quite visible from the house of PW4 and there was no obstruction in any manner. The Learning Council further argued that at the instance of the appellant, basing on his statement, the weapon of offense was seized from the place of concealment at the instance of the appellant, and the said weapon was sent for examination to the doctor who conducted post-mortem examination, and he has opined that the injuries on the body of the deceased were possible by such weapon, and moreover, when the weapon was sent for chemical examination, the chemical examiner found human blood on the cautery, and the conduct of the eyewitness PW4 in immediately disclosing about the occurrence before PW5 is admissible as registy under Section 6 of the Evidence Act, and therefore the even if the prosecution has failed to establish any motive behind the commission of the crime, but in a case of direct evidence, motive loses significance, and when the version of PW4 coupled with the post-mortem report finding indicates that the ocular version is corroborated by the medical evidence, and the Learning Trial Court has rightly accepted her version. He submitted that the manner in which the deceased was assaulted and the blows were given repeatedly on the vital part of the body, and the impact of such injuries clearly shows that the appellant intended to commit murder of the deceased, and therefore there is the um, uh, there is no infirmity in the or illegality in the judgment, and the appeal should be dismissed. Adverting to the contentions raised by the learned counsel for the respective parties, coming to the we will first decide whether the prosecution has successfully established that the deceased met with homicidal death. The investigating officer conducted inquest over the dead body at the spot and prepared the inquest report, and it shows how the deceased had sustained number of injuries on different vital parts of the body. The doctor who conducted postmortem examination PW7 like that has found the following injuries, quote the injuries. He has opined that all the injuries are antemortem in nature, and the age of injuries are was more than 24 hours and within 48 hours. And the um, he has opined that the cause of death of the deceased was due to massive hemorrhage and shock caused by the injuries. He specifically stated that the death of the deceased was homicidal in nature. Nothing has been brought out in the cross-examination uh, except putting one question by the London State Defense Counsel that the postmortem abrasions on the backside of the deceased were possible by dragging of the body. Therefore, in view of the unchallenged testimony of the doctor, uh, we are of the view that the London trial court is quite justified in holding that the prosecution has successfully established that the deceased met with homicidal death. The star witness on behalf of the prosecution is none else than PW4, Srimati Champa Pingua, who stated that the appellant was her brother-in-law, bracket husband of her cousin sister, and the deceased was her cousin elder sister. She stated that on the date of occurrence, she was suffering from fever and sitting on the outer veranda of her house with her breastfeeding daughter. And at that time, she saw the appellant was chasing the deceased from his house and assaulted her by means of a katari, for which she fell down in front of the house. And out of fear, she left the place with her child and came to the house of PW5, with the maternal uncle by village Corsi, and narrated the incident to PW5. In the cross-examination, the PW4 has stated that her house is adjacent to the house of the appellant, and her husband was absent at the time of occurrence. She denied the suggestion given by the London Defense Counsel that there was land dispute between her husband and the appellant since last 2 years, for which she was not in good terms with the appellants. Nothing has been brought out in the cross-examination of PW4 to disbelieve her evidence. PW5 has stated that the appellant was his Bhaniji Jui and the deceased was his niece bracketed Bhaniji. He stated that while he was working in his paddy field, PW4 came to him and told that the appellant had committed murder of the deceased by means of a cutlery in his house, and on getting such information, he came to the house of the appellant and saw the uh, deceased lying dead. Therefore, the evidence of PW4 regarding disclosure of the incident is not only getting corroboration from the evidence of PW5, but the conduct of PW4 in disclosing the incident before PW5 immediately after the occurrence is admissible as res geste under Section 6 of the Evidence Act. The materials on record further indicates that the PW4 intimated PW1 about the death of the deceased on the next day morning, and on getting such information, PW1 proceeded to the house of the appellant and saw PW1 is none else than the informant of the case, and he is also the younger brother of the deceased. Was stated that about so and so Jota Dakili, and came to the house of the deceased and saw the deceased lying dead on the veranda of the house of the appellant. And there were cut injuries on her neck and other parts of the body, and the appellant was found absent in his house. The other witnesses who accompanied PW1 to the house of the appellant on that day are PW2 and PW3, as stated by PW1. And PW2 also stated that when he came to the house of the appellant along with PW1 and others, he saw the dead body of the deceased lying there with injuries on the neck and other parts of the body, and the appellant was found absent. PW3 has also stated similarly, corroborating the evidence of PW1 and PW2. The IO received the information, IO bracketed PW9 received the information about the surrender of the appellant at Gudgudia outpost on 14/10/2007 and on 13/10/2007 and on 14/10/2007, and then after making a station diary entry, he proceeded to Gudgudia outpost. Huh? 13/10, and found the appellant had surrendered in that outpost. The IO further stated that when he came to the village, PW1 presented the written report before him at the spot, which was treated as FIR. The IO further stated that on 14/10/2007, at about 4 p.m., the appellant was arrested, and while in police custody, he confessed his guilt and stated that he had concealed the cautery near a bush in village Goldmund, and if the police party would go with him, he would show the place of concealment. And so saying, he led the police party and the witnesses to the place of concealment and showed the and brought out the weapon of offense, that is cautery, from the place of concealment underneath the bush and handed over the same to PW9. The statement of the appellant recorded under Section 27 of the Evidence Act in a separate sheet has been marked as Exhibit 3, wherein the no and the seizure list of the weapon of offense has been marked as Exhibit 4. The who witnessed the corroborate portion? The PW2 and PW3 corroborated the version of the investigating officer leading to discovery of the weapon of offense. Law is well settled that so far as Section 27 of the Evidence Act is concerned, that the first condition necessary for bringing into operation is the discovery of fact, albeit a relevant fact, in consequence of the information received from a person accused of an offense. The second is the discovery of such fact must be deposed to. The third is that at the time of receipt of the information, the accused must be in police custody. And the last but most important condition is that so much of information as relates distinctly to the fact thereby discovered is admissible. The rest of the information has to be excluded. The extent information admissible must depend on the exact nature of the fact discovered to which such information is required to relate. In case of so reported in AR 1976 Supreme Court 483, it is held that when the accused stated that I will tell the place of deposit of 3 chemical drums which I took from Haji Bandar on 1st August, only the first part of the statement, that is, I will tell the place of deposit of 3 chemical drums, was held to be immediate, the direct cause of the fact discovered, and therefore admissible under Section 27 of the Evidence Act. Information as to the past user or the past history of the object produced is not related to the discovery in the setting in which it is discovered, and therefore it is inadmissible. Therefore, only that much of statement made by the appellant in custody during investigation to the police is admissible as leads to the recovery of some article or thing, and any other part of the statement which is not related to the recovery of the article is not admissible under section 27 of the Evidence Act. Though the entire statement has been marked as exhibit by the London Trial Court as exhibit 3, but all the same, it was necessary on the part of the London Trial Court to mark that portion of exhibit 3 specifically where the information given by the appellant relating to the discovery of the place of concealment of weapon is stated. The um, in view of the evidence of the IU relating to the leading to discovery of the weapon of offense, which is corroborated by the evidence of PW2 and PW3, we find that the prosecution has also established this part of the evidence. The weapon of offense after its seizure was sent to the doctor, bracket PW7, who conducted postmortem examination, and he opined on examination that the injuries found on the body of the deceased were possible by means of the Qatari, and further stated that the Qatari is sufficient to cause death of a person in ordinary course of nature. The query report of the doctor has been marked as Exhibit 8. The weapon of offense has been proved during trial as MO1, which was sent also for chemical examination, and the chemical examination report indicates that there was human blood on the cautery. Therefore, the prosecution case that MO1 was used by the appellant committing the murder of the deceased is also established by the prosecution. The contention of the London Council for the appellant that the witnesses are close relatives of the deceased, and therefore there is chance of false implication of the appellant cannot be accepted in view of the fact that they are also related to the appellant, and moreover close relatives are not necessarily the witnesses who has to depose falsely, sparing the real culprit and implicating somebody falsely. The the manner in which the assault has been made, and in absence, even though the prosecution has not proved the motive behind the commission of the crime, but when direct evidence is available on record, motive loses significance. And in the case in hand, the appellant not only chased the deceased, but being armed with a cautery and assaulted him repeatedly on a vital part of the body like neck, and the injuries caused are so serious that um, the intention of committing murder could be easily uh, deduced from that. The Lenin trial court has there is no material on record to bring the case within any of the exceptions as enumerated under section 300 of the Indian Penal Code. After carefully going through the evidence of the eyewitness bracketary PW4, the evidence of the doctor PW7 and other materials available on record, we find that the prosecution has successfully established that it is the appellant who has committed the murder of the deceased. खाली गोटे लाइन गोटे पैराग्राफ रे लिखिबे पूर्वरु, though the Lenin trial court has observed that the appellant made extrajudicial confession before PW2 and PW3, and such evidence appears to be voluntary and without any coercion, but it appears from the evidence of those two witnesses that while in police custody, the statements were made, and therefore the confessional part uh, is cannot be taken to be admissible in view of the bar under section 25 of the Evidence Act. In view of the foregoing discussions, we find that the Lenin trial court has rightly came to the conclusion that the prosecution has successfully proved that the appellant intentionally and knowingly committed the murder of the deceased and convicted the appellant and found the appellant guilty under section 302 of the Indian Penal Code. Therefore, the appeal being devoid of merit stands dismissed. Yes, Mr. Mishra. Anybody else is present?
46. Item 46.
You have gone through it.
But, I have gone through the witnesses, but I don't have the full paper book.
You supply the paper book and you get ready so that we can take up this matter tomorrow.
Not sure.
Okay? Supply the paper book.
I want to mention my lord on criminal appeal, my lord 82 of 2019 orders bail, my lord. More than 7 year custody. My lord, criminal appeal 315/2023 list ଥିଲା କଟି ଯାଇଛି।
कौन फाइन?
मुझे कोई पता
Is it for bail or for hearing or what? What purpose you are mentioning?
for bail.
June.
Item 26 from the list, my lord. Out of 10 years, he is already in custody since 9 years. I filed an IA for bail.
All right, wait, yes.
My lord, criminal appeal number 259 of 2010. It was heard on by before on news office on 27th April 2022. And the date was fixed for CBI's argument on 29th June 2022. Thereafter, minor after change of
You want it to be listed?
now, today this matter is listed at item 22. The Lordship had earlier called on this matter on 16th.
Why are you making mention? I will go serially and take up the matter.
If it is possible, my lord, it may kindly be heard in part so that.
No.
Matter, vigilance matter, item 59, Lordship. What the pension benefit is held up. And wife is suffering by the spinal cord to be surgery, Lordship. But any date, my Lordship, convenient date to fix, Lordship.
Yes. Call the matter.
No, item not 49, Lord. After death of the Smriti Rajan Mahapatra, I filed a Bhokalatanama. Last time directed to insert our name.
Lordship, BLAPL 2344 of 2023. Lordship, one IA has been filed regarding extension of entry model, Lordship.
Yes.
Weekly list, item number 1.
May I please, Your Lordship? Lordship, I'm appearing through virtual mode, Your Lordship. I'm appearing on behalf of Mr. Devashan Das. Lordship, 1 week time may kindly be granted.
No, it's a 2001 matter. Why 1 week time will be granted?
Any other date, Your Lordship?
No, I'm recalling the bail order. He will be arrested and taken into custody. Thereafter,
Yes, Your Lordship.
देखिए ये तो जो अपील रेकॉर्ड था It's a 304 part 2 and 7 years. So a mention is made on behalf of Mr. Devasnan Das for adjournment. This criminal appeal is of the year 2001. The appellant Kalia alias Manos Kumar Das has been found guilty under section 304 part 2 of the Indian Penal Code by the Learned Session Judge Khurda at Bhubaneswar in ST case number 123 of 1999 and sentenced to undergo rigorous imprisonment for 7 years. The appellant was granted bail by this court by order dated 8/8/2001 in Miss Case number 43 of 2001. Subpara. I am not inclined to grant time to the Land Council for the appellant. The bail order dated 8/8/2001 stands recalled. The appellant shall be immediately taken into judicial custody. The Lenin Trial Court shall issue non-bailable warrant of arrest against the appellant and the Superintendent of Police and DCP like them, DCP Bhubaneswar shall take necessary steps for the arrest of the appellant at an earliest. The report shall be furnished to this court by the London Trial Court immediately after the appellant is taken into judicial custody. The copy of the order be communicated to the London Trial Court forthwith by the registered judicial through email for compliance. Yes.
May I please your lordship? Lordship, due to illness of the conducting counsel, lordship.
Yes, next item.
Lordship, any day, lordship.
Item number 2.
Tomorrow, lordship.
Yes, item number 2. Then file them. In this case, my lord, charge is framed under section 376, but intention 354 for 6 months. So that is why he has challenged that out. None appears for the appellant. The appellant faced trial in the court of London Additional Session Judge Board in ST case number 15 of 2000 bracket ST 80/99-DC for offense punishable under section 376 of the Indian Penal Code. However, the London Trial Court by judgment and order dated 16/12/2000 though held the appellant not guilty under section 376 of the Indian Penal Code, but found him guilty under section 354 of the Indian Penal Code and sentenced him to undergo RI for 6 months. The appellant was granted bail by this court in miscase number 47/2001 by the order dated 22/2/2001. Since none has appeared for the appellant and the matter criminal appeal is of the year 2001, the bail order dated 22/2/2001 is recalled. The London Trial Court shall immediately issue warrant of a non-bailable warrant of arrest against the appellant and the inspector in charge of Bausuni police station shall execute such warrant and arrest the appellant and produce him before the trial court. The London Trial Court shall report this court about the arrest of the appellant. A copy of this order be communicated to the London Trial Court for compliance to email. Yes, next.
Item number 3. May I please, your lordship?
Yeah. Yes.
Lordship, in this case, there are three appellants, Lordship. The appellants are face trial under section 302, 201, and 34 of IPC, Lordship. After completion of trial, they were acquitted for the offence under section 302 and 34 of IPC, and convicted for only of the offence 201 of IPC, and sentenced for 1 year, Lordship. The operative part, Lordship, page 41 of the paper book.
Yes. Yes.
The total 8 number of witnesses has been examined. PW1 is the informant, PW5 is the doctor.
No. Where is which paragraph the reasoning has been assigned so far as the offense under section 201 of the Indian Penal Code? Is it paragraph number 29?
Yes, Your Lordship.
Read out that.
In this case, the prosecution has not been able to prove that the death of the deceased was homicidal through the doctor or through any other piece of evidence. And PW1, although has stated to have seen the dead body of her husband Manoj have been carried by the accused person, and also has narrated the circumstances prior to this, she has not seen the alleged killing of her husband. In this circumstance, it cannot be pinpointedly concluded that the death of Manoj was homicidal. The circumstance was proved by the prosecution that the accused persons were ill-treating Manoj, and they went to the extent of assaulting him, denying food to him, making him separate from them for some time, and avoiding PW1 to enter into the Boitakana sitting room at the relevant time. To uproot mustard plants and carrying of the dead body of Manoj by them, as well as their absconding after the dead body was discovered, and not last.
They all were last seen with the deceased.
Deceased are sufficient to suspect that the accused person might have killed the deceased. Law is well said the suspicion, however strong it may be, cannot take the place of proof. There is a gulf of difference between the action might have been done and must have been, since the entire prosecution case relied on circumstantial evidence, and law is well said that there must be a chain of evidence so far complete as to leave no ground for conclusion consistent with the innocence of the accused, and must be to show that within all human probability the act must have been done by the accused. In the instant case, taking all this incriminating circumstances against the accused person into account, I find that the chain is not completely conclusive. Hold that the death of the deceased must have been caused by the accused person and not by any other means.
So that is the reason for acquittal under 302.
Yes, Lordship.
Yes. तापरे कौन कहले?
However, the incriminating circumstances proved by the prosecution in this case, as discussed above, clearly disclose that accused person have tried to disappear the evidence with the intention of screening themselves from legal punishment. In this case, admittedly, the deceased was the son of the accused Padavendra Kausalya and own brother of the other accused, Saroj, the appellant 1, 2, and 3. According to them, Manoj was absent since some days prior to the discovery of his dead body in the paddy field called Mahabinanola, but they have not lodged any information before police, nor they have been shown any anxiety for the return of their son. The behavior of the accused Padavendra at the site of the dead body of his son Manoj is not compatible with the natural behavior of a father, and the witness have stated that he was there at a distance and was watching the situation. Being called by the police, he came near the dead body and identified it to be Manoj, and since then all the accused person
Were absconding.
were absconding.
Had they been
Quite innocent.
Quite innocent in the matter.
They must
They must have helped the police
police
the investigation officer
to unearth the regarding the death of
the deceased.
They were
in the investigation officer, Circle Inspector of the Police of Jaliswar. They are also deposed the search for the accused person in all probable places. All these facts and circumstances lead to an irresistible conclusion that these accused persons tried their best to disappearance of evidence with regard to the intending to screen themselves from legal punishment. Thus, they are liable to have committed the offence under section 201 of the IPC In the result, the accused person are found to have not committed the offence under section 302 IPC, and hence they are acquitted therefore. But as I have already indicated above, the accused person have found to have committed the offence under section 201 of IPC, and accordingly find them guilty to have committed the offence under the said section, and hence I convict them thereunder.
So you come to the charge, page 50. So far as the second charge,
Yes, Lord.
201 is concerned, read out that charge.
That you on or about the same day and place, knowing that the certain offence with murder of Mano Senapati alias Sambhu, punishable with death or imprisonment for life, and fine has been committed, did cause certain evidence of the said offence to disappear by throwing away the dead body with an intention of screening yourself from legal punishment. In further of your common intention, thereby committed an offence punishable under section 201, read section 34 of IPC.
So what has been observed by the trial court that in this case, admittedly, the deceased is the son of accused Padabendra. Padabendra means he is
Appellate number 1, father of the deceased.
And Kausalya is appellant number
2, mother of the deceased.
And his own brother,
Sauro Senapati, appellant number 3.
Okay. According to them, Manoj was absent. Manoj is the deceased.
Yes, Lord.
Was absent since some days prior to the discovery of his dead body in the paddy field called Mahabina Nala. But they have not lost any information before police, nor they have shown any anxiety for return of their son. The behavior of the accused, Padabendra, at the sight of the dead body of his son is not compatible with the natural behavior of a father, and the witnesses have stated that he was there at a distance and was watching the situation, and being called by the police, he came near the dead body and identified it to be that of Manoj. And since then, all the accused persons were absconding. Had they been quite innocent in the matter, they must have helped the police to unearth regarding the death of the deceased.
That aspect, appellant to a mother.
They were absconders. Such a The investigating officer has deposed to have searched for the accused persons in all probable places. So therefore, the irresistible conclusion is that these accused persons tried their best for disappearance of the evidence. Yes, Mr. Tripathi, एमाने समस्ते होचंती डिसीज्ड रिलेशन दी जने होचंती बापा जने माँ और जने होचंती भाई से डिसीज्ड किछि दिन धरिकिनी ता घरु चल जाइथिला तो एमाने किछि इन्फॉर्मेशन देई नथिले ठीक अछि तेणु से जो फाइंडिंग आसिला जे से माने इन्फॉर्मेशन देई नथिले एंजाइटी देखेले नाही for the return of their son. आउ जो appellant number 1 जेतेबेले डेड बॉडी मिलिला से पैडी फील्ड रु सी गोटे ଦୂରରେ ଛିଡ଼ା ହେଇଥିଲା ଏବଂ ତାପରେ ପାଖକୁ ଆସି पुलिस डाकिबारु से डेड बॉडी को चिन्हेला जेटा होची मो पुओ मनोजर आउ तापरे से माने ए बापा माँ आउ भाई एमन तीन जन जाको फेरार ही जाइथिले so how this is sufficient to establish that they have caused disappearance of the evidence. You have acquitted them under section 302 of the Indian Penal Code. So once there is no material that they have committed murder, the 201 requires a IPC then. Yes, CRPC or 201 by eta bar. Come to 201. It reads like this: causing disappearance of evidence of offense or giving false information to screen offender. Whoever knowing or having reason to believe that an offense has been committed causes any evidence of the commission of that offense to disappear. Keep Padi Guruji. With the intention of screening the offender from legal punishment, or with that intention gives information respecting to the offense which he knows or believes to be false. Real. So once the trial court has acquitted him of the charge under section 302 that they have not committed the murder. So where is the material that they knew that the murder has been committed? Yes. Because the section requires that they must be aware, they must have knowledge, or they must have reason to believe that an offense has been committed. When you have acquitted the person that they have not committed the murder, then you are to bring on material that first of all that the deceased died a homicidal death, and that was they are aware that it was a homicidal death, and they had knowledge or they had belief that an offense has been committed. And if having that knowledge or having that belief, they cause the evidence of commission of that offense to disappear for screening the offender, then the offense should be attracted, or it would be attracted when they give any information respecting the offense which they knew or believed to be false. A part to totally nahi. Se mane konosi false information na police pakhare na kaha pakhare deichanti. Tenu a part ta gala. Baki kon evidence se mane disappear kale, having knowledge khali disappear kale habani. Hala se jani thibe je ei dwara ei goটা offense ta hei jaichi. Mane koro goटे बाडीटा यूज ହେଇଛି ମାରିବାରେ, ହେଲା ସେମାନେ ଜାଣିଛନ୍ତି ଏ ବାଟଟା ୟୁଜ ହେଇଛି, ବାଟଟା ଏଠି ଜାଗାଟେ ପଡିଛି କି ରକ୍ତ ଛିଟା ପଡିଛି, ସେମାନେ ସେ ବାଟଟାକୁ ନେଇକିନି ଆଉ କୁଆଡେ ଫୋପାଡ଼ି ଦେଲେ, ରକ୍ତକୁ ଧୋଇ ଦେଲେ, ହେଲା ୱେପନଟାକୁ ନେଇ ଲୁଚେଇ ଦେଲେ. ତ these are the things which can be said that they try to cause disappearance of evidence. ତେଣୁ ଏଠି ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଆସିଲା ଯେ ତାଙ୍କ ପୁଅଟା is a grown up boy. He had gone somewhere and they have not reported the matter to the police. If this is the circumstance, can it be said that they were aware that his murder has been committed? पुओ जदि कुआडे बाहर को चल जाइछि फेरिनी केबे ଗଲା ଏବଂ ତାର dead body କେବେ ମିଳିଲା? They may be hoping that when the deceased was found missing.
Lordship, as per PW1 statement, the occurrence was held on 26/2/1997, Your Lordship.
PW1 is the wife of the deceased man.
26/1/2000.
26/2.
26/2/2000.
1997.
अच्छा 26/2/1997.
Yes, Your Lordship.
সেই দিনও deceased was found missing.
The PW1 stated that at that time of night, he saw that the appellants were carried the dead body of the deceased.
କାଇଁ ଆସିଲେ ପଢିଲେ ସେଟା
Yes.
PW1 ନ ପଢନ୍ତୁ.
I know the accused person. They are my mother-in-law, father-in-law, brother-in-law. My husband died 2 years back in my matrimonial house. The accused person have killed my husband. After my marriage, I was staying in my matrimonial house on the previous day of his death, which was a Tuesday. My husband asked for food to his sister. She told that she would not give food to him. Throughout the day, he was made to starve, and he in the evening only he took some bhuja. His parents, brother and sister were assaulting my husband and did not allow him to take food. And these accused persons are also assaulting my husband, as my husband took bhuja in the evening on that day. Accused Kausalya, who is mother-in-law, abused my husband, and in the night also the accused one did not give the food to him. I also did not take any food in the night. On the next day, that is Wednesday, in the morning at about 7:30 a.m. After I finished my work, my mother-in-law sent me to uproot mustard plants from the land which was at a distance from my house. Accordingly, I went to their field about 9 to 10 a.m. I returned back from the mustard field. At that time, my husband asked for food to me. By then, the kitchen was locked. I told my husband that the key was not with me, so I could not give food to him. My husband then told me that he not take any food, so saying he dragged the lock and opened it, went inside the kitchen and took food. Thereafter, the accused Kausalya abused my husband, uttering "Toro aji marana hebo to bappa asu." Then in the afternoon, my mother-in-law sent me along with my nonanda sister-in-law to uproot mustard plant in the mustard field. When I returned back, I found that our Boitak Khana was locked. Then I asked my mother-in-law to open the door so that I will clean the room. Then my mother-in-law replied that she had already cleaned the room and asked me to clear the other parts of the house. Then I cleaned the other part of the house. Then I asked my father-in-law about the whereabouts of my husband. He replied that my husband had gone inside my village. Then it was right. Both my parents-in-law asked me to take food and sleep. I told that after my husband returned, we'll take food. Then I went to inside my bedroom, and my mother-in-law also spread her bed at the doorway and slept there. Then I asked my mother-in-law as to why she should sleep in my bedroom in that night. She replied that I might get fear by sleeping alone in the bedroom, so she wanted to sleep there. In the dead of the night, my mother-in-law came out of that room by slowly opening that room. By then, I was not asleep and I was waiting anxiously for my husband. Then I came out of that room and saw my mother-in-law standing at the doorway of the Vaitakhana, which was locked up. Then I found accused Padavendra Senapati and Saraswati, who are my father-in-law and brother-in-law respectively, who are bringing the dead body of my husband from the Vaitakhana. Seeing this, I started crying. Then my mother-in-law gasped my mouth and by putting her hand, they then accused Saroj rushed at me holding a knife and threatened me if I disclose it before anybody, then he would kill me. Thereafter, I lost my sense. When I regained my sense, I found myself sleeping in my room. On the next day morning, my mother-in-law sent me to mustard garden forcibly. After I returned from the mustard garden, I found that Boitakhana was cleaned by mud and cow dung. After 15 days of the date of the occurrence, I lost the FIR at the police station, Your Lordship. I was frightened by the accused as well as I lost my balance of mind due to the death of my husband. The delay was in lodging of FIR in PS. I submitted this written report at the police station scribed by my uncle PW2 Ravindra Das, Your Lordship. As per instruction, Exhibit 1 is the said report. The contents of the same were read over to me, and there, after I put my LTA there on the scribe, Ravindra Das signed in Exhibit 1 in my presence. I've also stated the occurrence before the magistrate under section 164 CRPC. The dead body of my husband recovered from the paddy field, which I identified. I have been examined by the IO. Cross-examination. I only gave my statement before the magistrate at Jolly, so I hadn't filed any petition or affidavit, Your Lordship. After the occurrence, he filed an affidavit that the appellants were innocent, Your Lordship. My uncle had gone with me. I don't know who is affidavit, what is affidavit. 4 to 5 days after, the death of my husband, I saw his dead body in the paddy field. I came from my matrimonial house to the paddy field, saw the dead body of my husband there from left for my parents' house. My uncle Ravindra called me when I was in my matrimonial house and to see the dead body of my husband in the field. Then I accompanied him to that spot, saw the dead body of my husband and left for my parents' house. It is not a fact that I stated before the IO that my uncle Ravindra called me to parents' house saying that my father was ill and that when I was in my parents' house, I got information that dead body was lying in the paddy field and then I come to that field with my father and identify the dead body of my husband in the paddy field. This part, she said that he come to the paddy field with her father. But PW2, the uncle of the informant, said that he took the informant to the paddy field. And PW for the father also said that. He sent the uncle to the informant's house to the place. On that day, my uncle Rabindra informed about into the police. Police came to interrogate me in the same day night. At that time, I had lost my balance of mind. It is not a fact that I have stated before the IO that in that night, that is Wednesday night, I slept in the night and wake up in the early morning. It is a fact that in the UD case, I have not stated before the police that I saw my brother-in-law standing on the door of the Vaitakana, my mother-in-law and brother-in-law bringing the dead body of a husband from that room. And when I cried, my mother-in-law gasped my mouth and that my brother-in-law rushed at me holding a knife and threatened me to kill. I have not stated this thing before the police out of fear of she showed a knife to kill me if I disclosed. She didn't told anything before the police, your lordship, when the UD case was registered.
Yes.
After I left my matrimonial house with my uncle, I have not returned back to that house. On the Tuesday, as my sister-in-law Dharitri did not give food to my husband, he dealt 1-2 slaps to her. Dharitri abused my husband. It is a fact that I have not stated before the police in the UD case that my mother-in-law had abused my husband, telling that Toro Morona Bela Aslani Bappa Asu. That part is said in the examination chief, your lordship. He did not stated before the police. I had been to Jaleshwar court once in connection this case, so also once to the police station. Immediately after the exhibit 1 was scribed, I went to the police station and submitted it. It is not a fact that it is submitted at the police station 6 days after I put my LTA on exhibit 1. It is not a fact that my father-in-law and brother-in-law have got a number of enemies. It is not a fact that submitted an application on affidavit before the Jaleshwar court stating that the enemies of father-in-law and brother-in-law have falsely implicated the accused person in this case by taking my LTI in exhibit 1 and subsequently using it as an FIR. It is not fact that my uncle Rabindra had also come on Friday after the death of my husband and thereafter again he came on Sunday. It is not a fact that I have stated before the IO. It is not a fact that I had my uncle on Friday, but I had not narrated the incident before him. He had only come on Sunday. His parents' village adjoins the village of my maternal. She do not tell the incident about to his uncle, your lordship. The mustard field is inside our homestead. Our homestead is by a big area and the mustard field is situated at a distance of about 1 or 2 miles away for our residence. There are houses near to the house of my husband. The house of my uncle-in-law, Radhesyam, is the next house of my maternal house, intervened by the house of my middle uncle-in-law, Jadu Senapati. On Thursday, mother-in-law forcibly sent me to the mustard garden while our homestead and villagers were get outside and not call them, narrate the incident before them. The accused person were not allowing me to go outside the homestead. I was sent to the mustard field in the earlier morning, returned back at about 9 a.m. on Thursday. I did not try to go to the house of my parents through the mustard field, through the paddy field. It is not a fact that afterwards we have made up a story against the accused person staying in my parents' house. It is not a fact that I realized the fault, came to Jaleshwar court, filed an affidavit stating that no such incident had taken place. I have done a mistake by implicating my in-laws. It is not a fact that the accused person have not killed my husband. I had seen them carrying the dead body of my husband.
So far as this evidence of this PW1 is concerned, the relevant part, which is for the offense under section 201
At
of
page
the
77.
Indian Penal, is that is in page number 77.
Yes, Lord.
Then I came out of that room and saw my mother-in-law standing at the door. We of the Boitok Khana, which was locked up. Then I found, this is important, then I found the accused Padaravindo Senapati and Sarosh Senapati, who are my father-in-law and brother-in-law, were bringing the dead body of my husband from that Boitok Khana. Seeing this, I started crying. Then my mother-in-law gagged my mouth by putting her hand, and then accused Saroj rose towards me by holding Swanso and threatened me. If I disclosed it before anybody, then he would kill me. Thereafter, I lost my son. So, if this part is believed that the dead body of the deceased was in the Boitok Khana, and in the night, you three appellants made attempt to remove that dead body from that Boitok Khana, and in spite of protest of the PW1, you threatened him, then there would be material that, but whether this particular part of the evidence of the prosecution that the murder took place in Boitok Khana, or the dead body was there in Boitok Khana, has been accepted. Anything was found from that Boitok Khana during course of investigation, because unless the dead body was there in that Boitok Khana, there is no question of removing that body from that Boitok Khana to any other place. If that is not there, then screening of offense would not arise. ତେଣୁ ଆପଣଙ୍କର finding କ'ଣ ଆସିଲା? Why they have been acquitted under section 302 of the Indian Penal Code, and what finding there it has been reached, that because as we find that how far this evidence of PW1 has been accepted, or what part has been accepted, what part has been disbelieved. So, in which page or paragraph the evidence of PW1 has been discussed?
Para 9.
Huh?
Para 9.
9.
Page 19. The FIR has been lodged by PW1. The FIR has been lodged by PW1.
Nine माने पेज केते बुझन?
Page 19 of the paper, Lord.
19 अच्छा PW1 नो एविडेंस आरंभ बला ये ताकू डिस्कशन कर देले. What is the finding after discussing the evidence of PW1? What finding the London Trial Court has given? Okay, you come to paragraph number 10. That is page 23. Read it out.
PW1 was cross-examined at length. Attempt was made by the defense to prove it that she has submitted an affidavit before the learned JMFC Jodheshwar, and in that matter, a suggestion was put to her to which she has flatly denied that she had submitted an application and an affidavit before the learned JMFC Jodheshwar, stating that the enemies of her father-in-law and brother-in-law have falsely implicated them in the case by taking her LTI and subsequently using it as the present FL, etc. Having been failed in its attempt to establish the plea, the defense has examined DW1 Khalid Ahmad, an advocate also who has formally proved an affidavit to have been filed by Swapna Rani.
The PW1 informant.
A careful perusal of his evidence will show that he has got no direct knowledge about the swearing of that affidavit by PW1. As in the first line of his cross-examination, he has candidly admitted that he did not know Swapna Rani Senapati before he attested her LTI Exhibit A. He has not identified Swapna Rani Senapati before the court. He has not made any endorsement in the affidavit that before she put her LTI, he read over and explained the contents to her, and the same is admitted by her to be true, and then she put her LTI. His categorical evidence is that the clerk of advocate Anudho Kaitav Joyeswar, and he does not work under him. He has got his own clerical work. Thus, from his such evidence, it is crystal clear that he doesn't know the person said to be Swapna Rani. Further, PW1 has been examined by the court under section 164 after the date of filing of his affidavit in the court, that she has not breathed a word about her filing of any such affidavit. Much less she has not disclosed before the court about the matter narrated in the affidavit. On the other hand, she has categorically implicated the accused person to have committed a less crime, and her statement recorded under section 164 CRPC is fully corroborated by her evidence. Hence, it does not stand to reasoning that PW1 would come to court to file an application and to swear an affidavit that her LTI was taken forcibly and the same was utilized to submit written report implicating the accused person, and that her husband was in habit of going outside, etc., as narrated in the affidavit Exhibit A by 2. Thus, I find that affidavit Exhibit A by 2 and the evidence of DW1 can safely be ignored. Coming to the other evidence, it is seen that Dr. PW5 has deposed that on 3/3/97, he being the medical officer of Headquarter Hospital, Baleswar, on police requisition conducted post-mortem examination on the dead body at 4:40 p.m. and found that following: the dead body was in advanced stage of decomposition, face and limb mutilated and partly rotten away
by wild animals.
Bones, teeth, limbs were exposed. The dead body was full of maggots and abdomen distended. Both the legs were eaten away up to the level of ankle. Left palm was absent up to the wrist. On dissection, he found the intestine was distended. Stomach was filled with undigested food. Since the body was highly decomposed, no external injury could be marked. With regard to the cause of death, the opinion was reserved pending chemical analysis of viscera. Time since death more than 72 hours of postmortem examination. He has proved his postmortem examination report exhibit marks. He has further opined.
No, this part of the evidence has been accepted. Seeing the removal of the dead body.
Yes, ma'am.
From that Baitokhana, that has been accepted by the London trial court. So that is one of the reason also for this offense under section 201 of the Indian Penal Code. So how do you discard that evidence when you during the night he saw that accused Padarvindam Swanso, who were the Swanso, were bringing the dead body of my husband from Baitokhana. Seeing this, I started crying. Then my mother-in-law Swanso. Then the accused Ross Swanso and threatened me if I disclose before anybody he would kill me. Thereafter, I lost my sense. So, ଏତିକି ସିଏ ଦେଖିଛି, ଆଉ କେହି ବାଟରେ କିଛି ନବା ଦେଖିନାହାନ୍ତି?
No, Your Lordship. Entire conviction was depend on PW1 statement, Your Lordship. He was lost the affair after 16 days after, Your Lordship. That apart the fear, the part of fear, Your Lordship, on 2/3/1997, Your Lordship, when the dead body was recovered, he went to his father's house with her uncle, Your Lordship. And the fear part was not there, Your Lordship. To when the UT cases were investigated, to say to the police about this incident, Your Lordship, but it did not state anything.
See, this occurrence, date of occurrence is
26/2/1997, Your Lordship.
right. Date of lodging of the affair
16/3/1997.
1997.
Yes, Your Lordship.
So UDK, जो dead body was recovered when?
2/3/1997.
Where she stated that I was residing with my uncle and
Stated that or page 79 cross examination, Your Lordship.
70.
Page 79 para 5, Your Lordship.
Yes.
After I left my matrimonial house with my uncle, I have not returned back to that house. The first two lines, Your Lordship.
After I left matrimonial house with my uncle. जैसे date टा केबे?
Date that's above the. It is a fact that when the dead body was found, Your Lordship, at 78 last two lines, Your Lordship. I got informed the dead body was lying in the paddy field. Then I called to
code पढ़ुଛନ୍ତି?
Lordship, page 78 last two lines.
78.
Yes, Lord. Last two lines.
Yes.
I got information that a dead body was lying in the paddy field. Then I come to their field with my father and identified the dead body of my husband in the paddy field. On that day, my uncle Rabindra informed about it to the police. Police came and interrogated me in the same day at night. At that time, I had lost my balance of mind. It is not a fact that I have stated before the IO that in that night, that is Wednesday night, I slept in the night and wake up in the early morning. It is a fact that in the UD case, I have not stated before the police that I saw my brother-in-law, mother-in-law standing on the doorway of the Baitak Khana, my father-in-law and the brother-in-law bringing the dead body of my husband from that room. And when I cried, my mother-in-law gasped my mouth and that my brother-in-law rushed at me holding knife and threatened me to kill. I have not stated this thing before police out of fear, as he showed a knife to kill me if I disclosed to anybody. After I left my matrimonial house with my uncle, I have not returned back to their house. And he told his uncle and father about the incident after 15 days, Your Lordship.
এই जो घटनाटा what he is submitting that 26/2/97 ଆପଣଙ୍କର date of occurrence ଯଦି ସିଏ ଘଟଣାଟା ଦେଖିଲା 26/2 ରାତିରେ ତାକୁ ଡେଡ୍ ବଡି ଟାକୁ ନେଇକିନି ଯାଉଥିଲେ ସିଏ ତାପରେ ପାଟି କଲା କଣ ଧମକି ହେଲେ ସେନ୍ସଲେସ୍ ହେଇଗଲା thereafter he went to his father's place left the and she was staying in her father's place when the dead body was recovered. Dead body ta recovery ହେଇଛି 2/3/1997. UD case ଟା କେମିତି ଆଣିଲେ ଯୋଉ UD case number ଟା କେତେ?
So UD case number is
Who has stated that?
PW8, Your Lordship.
2/3 on that day written report of so and so. I took up inquiry on so and so. I sent the dead body for the postmortem examination. ତ ଯେତେବେଳେ ଡେଡ୍ ବଡି ମିଳିଲା ସେ ସେଇଥିପାଇଁ କହୁଛି ମୋ ବାପାଙ୍କ ସହିତ ମୁଁ ଜାଗାକୁ ଆସିଥିଲି ଯୋଉ ଜାଗାରେ ରାଇଟ୍ ଏବଂ ମୁଁ ଅଙ୍କଲ ମଧ୍ୟ ଆସିଲେ I got the information that a dead body was lying in the paddy field, and then I came to the paddy field with my father, identified the dead body. On that day, my uncle also informed about uh, about it to the police. Police came and interrogated me. And after I left the matrimonial home with my uncle, I have not left. The uncle केते number साखी?
Uncle PW2 your lordship.
PW2.
Yes, Lord.
Evidence कौन आछी?
The part of I got informed the dead body was lying field,
Yeah,
and then I come to that field with my father. She said that he come to the field with his father, with her father, your lordship. But PW, the uncle said that at page 83, your lordship, I bought PW1 to show the dead body of Manoj. She came, she saw the dead body of her husband, did not return back to her
Food पढ़ुचंदी.
page 83 last para 2 ର ଉପରୁ ଟିକେ just.
I'm
अच्छा.
reading from the beginning, my lord.
हाँ.
ସେଥିରେ ବି ଅଛି dispute. PW1 is my niece. I know the accused person who are the in-laws of PW1. Manoj Kumar Senapati was the husband of PW1. The accused person had killed him on 26 to 97. PW1 had married 4 years before the death of her husband. Before the marriage, Manoj was entirely looking after the household affair. Further, his father had recorded 2 acres of land in his name. Then subsequently, he got the land recorded in the name of all the 4 sons, including Manoj, to which Manoj was not agreeable. Thereafter, Manoj did not look after the household affair, for which his parents, brothers, and sisters got annoyed with him and started assaulting him. On 28 to 97, I had been to the village of Sukudakuria. The house of the accused person falls on the way from my village to village. While I was returning from village, at about 10 to 11 am, I found accused Kausalya standing in our barri adjoining the road. I asked her about family. She told that Manoj had left house since 3 to 4 days and had not returned. Then I asked her as to where Manoj had gone. She replied that Manoj was ill and he was telling to go to a temple for Adhya. He might have gone there or to some relation's house, and she also asked me to search for him. Then I returned home and told this to my brother. On the next day, which was a Saturday, my brother went to search for Manoj. He did not return back home on Saturday, and on Sunday he came and told that he could not trace Manoj out. On the same day, subsequently getting information that a dead body was lying in Mahavira Nola, myself, my brother Prasmadas went to that Nola and found the dead body of Manoj there. The Nola is inside the paddy field. Then I left for the house of the accused person. Then I brought PW1 to show the dead body of Manoj. She came, saw the dead body of her husband and did not return back to her matrimonial house.
हाँ तामाने से 2 तारीख रु जो 2 तारीख पर्यंत थिला कोडी ना ता सासु घरे थिला ता अंकल गला अंकल जाई किनी ताको आनिला से आनला परे से डेड बॉडी को आइडेंटिफाई करिछि ता परठु से पळेला कोठी ना ता बाप घर राइट so she did not return back to her matrimonial came with me to her parents house then myself and my brother went to the police station and informed the police acha यदि सेया हला what is the submission that this occurrence took place on this incident on 26 to 23 ର dead body मिलला ହେଲା ତାହେଲେ 23 ରୁ ସେ ଆଉରି କଣ ପାଇଁ ଡିଲେ କଲା 16/3/97 पर्यंत काहेकि डिस्क्लोज कलानी से जो घटना गुड़ाक जहाँ सी एफआईआर रे भी जहाँ लिखी जो डेड बॉडी को रिमूव करिया को नहीं जाउतले ए सब जिंस मते टाइप रो धमक चमक देले मार दबे बोली कहले आउ सेत पय मु बेहोश ही जाइथिली so this delay is and in between two things are there that there would be no fear because she was residing at that point of time in her parents' house. Hala? Number two, police has already started inquiry in that UD case. And inquiry during UD case inquiry also statements have been recorded. And this witness has admitted in page number 79 that it is a fact that in the UD case I have not stated before the police that I saw my mother-in-law standing on the doorway of Boythok Khana, my father-in-law and brother-in-law bringing the dead body of my husband from that room, and when he cried, so and so. So this is not stated during that UD case inquiry before police. Yes. But almost after that 14 days, she lost the FIR wherein all these things have been stated. See, circumstantially, PW1 is the sole witness so far as and rest. Second thing is that Boythok Khana ରୁ ଯୋଉ ମୁଭ୍ କରିକି ନେଇକିନି ଗଲେ ଆଉ କେହି ଦେଖି ନାହାନ୍ତି ବୈଠକ ଖାନାରେ କିଛି ମିଳିଲା କି ଯେ ଯୋଉ ଯେତେବେଳେ ସ୍ପଟ ଭିଜିଟ କରିଥିବ ଆଇଓ ସେଠୁ କିଛି ପାଇଲା କି ଏଠି ସେମିତି କାରଣ he has been accused, they have been acquitted under section 302 ସେଠୁ କିଛି ପାଇଥିଲେ ଆପଣ ଲିଙ୍କ ନେବେ ଯେ ସେଠୁ ଇଏ କରିବେ ଯଦି ସେଠି ଟୋଟାଲି ଘଟଣା ହେଇନି
ବୈଠକ ଖାନାରୁ ଲର୍ଡସିପ ଯୋଉଠି ଡେଡ୍ ବଡି ମିଳିଲା ତା ଡିଷ୍ଟାନ୍ସ ହଉଛି 3 କିଲୋମିଟର ବୈଠକ ଖାନାରୁ ମାନେ ଦ ହାଉସ ଅଫ ଦ ଆକ୍ୟୁଜ୍ଡ ପର୍ସନ ରୁ ଡେଡ୍ ବଡି ଯୋଉଠି ମିଳିଲା ତା ଡିଷ୍ଟାନ୍ସ ହଉଛି 3 କିଲୋମିଟର ଲର୍ଡସିପ
ଆଣ୍ଡ ରାତି ଠିକ ଅଛି କେହି ଦେଖି ପାରିବେନି ଅଲଗା କଥା but first of all you are to prove that when your evidence to substantiate the charge under section 201 causing disappearance of the evidence is that the dead body was there in the Boythok Khana and that was removed to the paddy field. अन्य तो कहीं देखिलेनी only evidence होची PW1 रे evidence जो evidence टाउ से inordinate delay ही disclosure करियागो जे PW से dead body टा बैठक खाना रे थिला कारण acquittal हे गले 302 so there is no evidence who has committed the murder or at least there is no evidence against this person.
से डॉक्टर अपन को नहीं से ऑब्जर्व भी करछंती जे जेहेतु सेटा होमिसाइडल डेथ की नेचुरल डेथ जणा पडुनी सेटका ही इज एक्सप्लेनेशन 302 लेखिछन
से भी कहजंती देयर आर नो एक्सटर्नल इंजरी ऑफ द बॉडी पार्ट लॉर्डशिप
स्टिल देन माय लॉर्ड आई प्रे लॉर्डशिप काइंडली टेकन ओवर दिस ऑन वेडनेसडे
no move aji it's not that I am in a hurry I just opening up so that you can get prepared mane karo accusation होची ए जगह रे डेड बॉडी थिला ताकू एमाने नेइकिनी बी जगह को नेले जोटा की गोटिए विटनेस देखिछि एवं से विटनेस कहा पाखरे कहूनी ता बाप घरे रहिले मध्य से विषय रे काउ कहूनी 15 दिन 14 दिन परे एफआईआर देकिन से विषयटा कहूची तो unless it is proved that the dead body B पाखरे dead body मिलिची बेली एविडेंस अछि धान सेटा होची धान बिल रे डेड बॉडी पडिथला से एविडेंस अछि किंतु unless it is proved that the dead body was earlier at a point then the removal theory is not acceptable once the removal theory goes then the causing disappearance goes right so you are to adduce some evidence that once this evidence is discarded ଏକ ନମ୍ବର ସାକ୍ଷୀର ଯଦି ଏଭିଡେନ୍ସ ଟାକୁ ଡିସକାର୍ଡ କରାଇଗଲା ଆଉ ତ କିଛି ନାହିଁ ନା 201 କୁ ଇଏ କରିବା ପାଇଁ ତେଣୁ ସେଇ ଲାଇଟ୍ ରେ ଆପଣ ଏକ୍ସାମିନ କରନ୍ତୁ ହେଲା
I pray one thing my Lord, let it be taken up on Wednesday.
हाँ କିଛି ଅସୁବିଧା
Okay. हमारे थर्सडे रे आसुची
हाँ
I pray for Wednesday.
अच्छा एटाକୁ सप्लीमेंटरी लिस्ट रे नै आसନ୍ତୁ होला What is your good name?
लॉर्डशिप एसएस लिंका
पूरा नाम कौन?
सिद्धार्थ शंकर लिंका
SI
SIDHARTH SHANKAR
हाँ
SHAN
ना दी
I prepared a memo of citation, Lordship.
No, memo of citation maybe on 201 how it is to be appreciated. That's a but so far as this part of the concern,
I've relied upon judgment in delay in FIR, Your Lordship. Thuliakali versus State of Tamil Nadu, Your Lordship.
the, um, you file the that memo of citation and give a copy to the also Running State Council. Have you given it? Give it the hard-in part for the and Mr. Siddharth Shankar Lenka, advocate for the appellants, and Mr. Rajesh Tripathi, London Additional Standing Counsel, in part. The London Council for the appellants file the memo of citation. Only memo of citation,
Yes, Lordship.
which is taken on record. Let a copy of the memo of citation be handed over to the London Council for the state.
Tomorrow, Your Lordship.
By tomorrow, put up this matter on 15th of November 2023.
Obliged.
Mr. Dwivedi had mentioned a matter, my lord, item 26.
Call the next item.
Item number 4.
He has been convicted under section 304
Yes.
part 2 for 10 years. Under the copies are ineligible, and I have also not get the paper book. May I pray after 7 days, I will be ready. And the second aspect is that
Hand
he has
over a paper book to him.
43 years, now 21 years, now must be 65 and more than that. No, in the meantime, no contact. So only a week after, my lord, I will be prepared. I'll place it before my lord. After about 4 years, some 2-3 months, was granted bail by the Senate Court, and he was all along in custody during trial.
Hand over ଦେଇଦେଲେ ସବୁବେଳେ କହିବାକୁ ପଡୁଥିବ ସେଇ ଗୋଟେ କଥା। ହଁ ତିନିଟା set paper book ସବୁବେଳେ ready। Those are the questions related to the eyewitness account. So witness Santosh Kumar Dalai is PW1, witness Sanatan Jena is PW6, and witness Gangadhar Dalai is PW7. They have, all of them have stated that on 16/10/1999 at about 4 p.m. on the river bank of Boitarani near village, so this appellant threatened Giridhari Barik with a knife and then chased him and stabbed him on his left abdomen. So এই evidence consistent রয়েছে, and that apart the doctor question number 8 ku pade asantu। Question number 8 hochi Dr. HP Parida, he is PW9. He stated that he examined Giridhari Barik on so found incised penetrating wound on his stomach and there was profuse bleeding. So, and he further, next question, question number 9. The doctor also examined the knife and opined that knife produced before him can cause the said injury. So these are the main
material
circumstance. Apart from that, next question is that at your instance that that knife was recovered, you produced the knife MO1 which was seized. So these are the main circumstances, incriminating material against you. That eyewitnesses account of 3 witnesses
coupled by the
and
medical,
coupled by the swan.
medical evidence.
So what is the conviction here?
10 years again.
304 part 2 10 years. So how many period, how much you have
4 years 2 months now checked off, around 4 years, not exactly completed 4 years 1 month some odd days, 4 years 1 month some odd days.
So when the occurrence took place?
It was
1999. Oh, that means it is 23 years have passed.
24 years nahi kya 11 mas aigala to about 24 and 16/10 date occurrence
24 years passed. So Mr. If that is the sentence, why not reduce it to period already undergone? Because of the passage of time, if the eyewitness evidence is not able to be dislodged, so je gote eyewitness ro statement place kale PW1 ta place kono ke eyewitness hochindi pura ke PW167. So one ta place kono.
I know the accused present in the dock. He is Rabindra Maji. He was residing in my village as a tenant in the rented house. I know this is Giridhari Barik. He is a resident of village Girigaon. On 16/10/2019 at about 4 p.m. accused stabbed him with a knife at the river bank of Boitarani near village Nabanga. Before the actual stabbing, deceased was threatening Giridhari Barik.
Accused was threatening.
Sorry, accused was threatening Giridhari Barik.
Giridhari is the deceased.
I guess. Sorry. And when the
latter ran
towards me, accused stabbed him with a knife to the left side of the abdomen. Then I had been to the riverbed to attend call of nature. Due to shouting, many persons gathered. Accused was apprehended and brought to my village. Information was sent to police and
On arrival of the police, accused was handed over. The injured was sent to headquarters hospital, Kangimjar.
So on the spot itself, he was chased and caught hold of
By
and
the
with
villagers.
that knife also.
By the knife.
Yes, and read the cross examination.
Passport is in.
I
It was about 30
30
cubits
away
from the accused
and Giridhari
Giridhari, where they were
having altercation.
traveling altercation on the river bed. One Ramo and Santra.
Sudarshan were present. Beside the
was present beside the accused and Giridhari. They did not physically intervene. I cannot say for how many duration they were having altercation. When I arrived, I have seen the exchange of hot words. The spot where the altercation was going on will be around 50 cubits away from Ferryghat. Though accused was chasing after Giridhari with his knife, but after reaching at me, Giridhari, he stopped, and at the time accused came to the front of Giridhari and stabbed with knife to his abdomen. I threw my cycle and apprehended accused Rabi Maji Gangadhare, who arrived there running, snatched knife from accused. I asked Giridhari to run away, and he complied. While running towards the river, Giridhari fell down as he could not run. Villagers gathered immediately thereafter. Rama Sudarshan Sanatan did not chase after the accused when he was chasing after Giridhari. I have seen knife in hand of Rabi Maji when he was having altercation with Giridhari. A polythene was covered in the handle of the knife, and over it a thread was tied. Shirt of Rabi Maji also got some blood stain by the stabbing to Girdhari. Accused was wearing that shirt when handed over to police. I do not know who lost the affair, but he was my villager. I cannot say definitely when police took Ravindra from my village, but it might be 6 to 6:30 p.m. Police then inquired from villagers about the occurrence. It is not a fact I have not stated before. I owe that there was altercation, and in course of altercation, Ravi Maji chased Girdhari and then stabbed. The parents of Girdhari arrived and they made arrangement for removal of injured to hospital. I have not taken detailed note of them. Girdhari was holding nothing before he was stabbed. Chintamani Dale was in charge of Ferryghat. There are candy plant bushes on the riverbed. Deceased Girdhari married at my village. His father-in-law happens to be our Bandhu. It is not a fact that AQ did not at all stab Girdhari and that I am speaking false, as the father-in-law of Girdhari is our Bandhu. Candy bushes are 6 to 7 feet in height.
So this evidence is not at all shaken, and the evidence of PW6 also come to page 42. You will find same thing he has stated, that at that time accused arrived there, stabbed a knife suddenly to the left abdomen of Giridhari Barik. There was profuse bleeding, which made me nervous, for which I ran away. And then Gangadhar and Sania Dori apprehended the accused. So before the stabbing, myself, so and so were assisting Girdhari Barik to get battery from the bank to Anju. So even if another witness is PW7, in my presence, accused chased Giridhari and pierced a knife to his abdomen. Sanatan, Sudarshan, Swanso shouting, directing me to apprehend the accused. Sonia managed to apprehend the accused. I snatched the knife from the accused due to stabbing. Giridhari fell down on the riverbed and due to shouting, many villagers won. So these three evidence, Mr. Chan, the three eyewitnesses version coupled with the version of the medical evidence, it is consistent that it is on account of the stab blow given by the accused, the death has taken place, and the weapon of offense was also seized from the appellant at the spot itself. He was apprehended at the spot. So, in circumstance, so the 304 part 2 से जो quarrel टा है जी grave and sudden provocation है जी बरी तब करी 304 part 2 करचंदी sentence टा को कोड करचंदी अच्छा I sentence RI for 10 years देखी तो देखियो कितने period जाई जी से
date of arrest 16/10/1999
देखी तो
subject to
बेटा कौन थी हाँ so we'll go to final form means के date of forwarding हला 17/10/1999 हला 16 रे arrest हला 17 रे forward हला and order sheet indicates accused was produced in custody
judgment with custody
produced in custody
High Court रे bail हला 19/11/2003
produced in custody okay so he was never released on bail and the judgment was pronounced on 15/12/2000 judgment custody then when he was granted bail देखी
19/11/2003 19/11/2003 रे this one
order sheet बार करो 19/11/2003 कहउछंती
तापर से
ठीक है जी
तापर बेल और बॉन्ड देला केबे देला कोइ परिबे नै डोंट
अच्छा धरो जेतिकी धरा सेटिकी देला ताले 17/10/1999 रु तामाने 2001-2-3 हाँ 4 years 1 month at least
2 days 4 years 1 month 2 days
अब reduce कर दो आई वर्ष 23 वर्ष हो गया Yes, Mr. Chand, what do you say?
And I'm ready for that, but one more thing also I want to, because the FIR has been lodged. It is the prosecution case as stated by the witnesses 1, 6, and 7, as my brother has pointed out, and my brother is also kind enough to go through that. There it has been alleged that on the spot the person was arrested and knife was seized. But as per the FIR, my lord, which has been lodged, subsequent to that, Bhujal is the weapon of offense. And nowhere it has been said that these people 1, 6, and 7 are the eyewitness before whom this stabbing was there. And besides this, my lord, and besides this, some witnesses are also saying that the weapon of offense is knife. Some are saying it's a bujali.
Knife. No, ये जो तीन जन साक्षी आपन को देले एक नंबर समस्त तो knife पूछन. They are the material witnesses who have seen the occurrence, and they all of them have stated knife. এবং knife ही सीज ହେଇଛି ଏବଂ knife ही ପଠାଇଛି ଡକ୍ଟର ପାଖକୁ. Doctor examine କରିକିନି positive opinion ଦେଇଛନ୍ତି, and knife was also produced during trial after that has been marked also marked as MO1. So भुजियाली कथा किए कहला
FIR को जाएगा में have a glass space 8 ना 10 ଥିଲା बोले पेपर बुक
कौन सामो गोटे भुजियाली रे हां
এবং সে witness must be examined
but अच्छी जे से मारला बेली ता पेटू को मारला ई सब
से पार्ट but and nowhere it is said
who is this witness गोपाल चंद्र चरण बारी
informant
PW2 No, this part has not been confronted to this witness.
Madam, that is it.
FIR is not a substantive piece of
Yes, madam,
evidence.
madam.
So you should have put that you have mentioned it in the that Bhujali. First of all, he is not a witness to the occurrence.
Madam.
After hearing that, he has lost the.
And this claim of this PW 1, 5, and 6 were claiming to eyewitness, that part is also absent in the FIR. Because it is also not
Clearly
mentioned.
because FIR does not indicate that who are the eyewitnesses.
Well, that is it.
And heard the learned counsel for the appellant learned counsel for the state. The appellant Ravindra Kumar Majhi faced trial in the court of Learned Session Judge Keunjhar in Sessions Trial number 50 of 2000 for offence punishable under section 302 of the Indian Penal Code for committing murder of Giridhari Barik, hereafter the deceased. On 16/10/1999 at about 5 p.m. at Bali, Borua. The London Trial Court, by judgment and order dated 15/12/2000, found that the prosecution has failed to prove the charge under section 302 of the Indian Penal Code. However, found the appellant guilty under section 304 part 2 of the Indian Penal Code and sentenced him to undergo RI for 10 years. The prosecution case, as per the a first information report lodged by PW2 Gopal Charan Barik, is that while the deceased was returning after repairing battery at Bali Borua, on the river bed of Vaitarani, the appellant stabbed him on his belly with a bhujali, as a result of which he sustained injuries and shifted to Ghasipur Hospital for treatment. In absence of the officer in charge, PW11 Satyendra Barik, the SI of Police of Ramchandrapur Police Station, registered the case on the basis of written report presented by PW2 as Ramchandrapur PS case number 56 dated 16/10/1999 under section 307 of the Indian Penal Code, and he himself took up investigation of the case. During course of investigation, he examined the informant, recorded his statement, proceeded to the spot, and then to the village Bali Borua, where he found that the appellant has been detained by the villagers. Stop. The IO examined the witnesses, recorded their statements, and the weapon of offense was produced from the possession of the appellant, which was seized under seizure list exhibit 5. The appellant was also sent for medical examination, and then he was arrested on 16/10/1999, and on 17/10/1999 he was forwarded to the court of London SDGM Anandapur. The IO came to know that the injured was has been referred to District Headquarters Hospital, Keunjhar. And therefore he prayed for recording of the dying declaration to the MO if felt necessary. On 20/10/1999, the IO received the information that the deceased succumbed to the injury in the early morning hour. Stop. Then the IO proceeded to the District Headquarters Hospital, Keunjhar, held inquest over the dead body, prepared the inquest report exhibit 2, and seized the bedded ticket of the deceased, and then sent the dead body for post-mortem examination. Through constables. After post-mortem examination, the dead body, the constable produced the wearing apparels of the deceased, which were seized as per seizure list, exhibit 4/1. And on 8/11/1999, the IO (PW11) received the post-mortem report. And on that day, Rajat Kumar Mishra (PW12), the Circle Inspector Anandapur, took over investigation of the case, and he sent the seized articles through court to SFSL Rasulgarh for chemical examination. And on completion of investigation, he submitted charge sheet against the appellant on 26/1/2000. Under section 302 of the Indian Penal Code. The defense plea is one of denial, and it is stated that there was previous dispute between the appellant and the deceased, and on the date of occurrence, while the appellant was proceeding towards his sister's house, on the way he was detained and falsely entangled in the case. Stop. In order to prove its case, the prosecution examined 12 witnesses. The prosecution also proved 13 exhibits and one material object. The London trial court, after analyzing the oral as well as the documentary evidence on record, has been pleased to hold that from the evidence of the doctor and the postmortem report, it has been proved that the cause of death of the deceased was due to injury to his abdomen, and the injury was homicidal, and it has also been proved that the injury was caused by knife bracketry MO1. The recovery of weapon of offense from the possession of the appellant has also been accepted by the London trial court. The London trial court, after analyzing the evidence of 3 eyewitnesses, that is PW1, PW6 and PW7, came to hold that there is no reason to disbelieve the prosecution case, as appears from their evidence that it was the appellant who was the author of the injury on the person of the deceased, and he caused the injury with knife bracketry MO1. The London trial court however held that there was no intention on the part of the appellant to commit the murder of the deceased, but the appellant had knowledge that such injury was likely to cause death, and accordingly held the appellant guilty under section 304 part 2 of the Indian Penal Code. Mr. Manas Chand, Land Counsel, appearing for the appellant, contended that even though it is the case of the prosecution, as per the statements of the 3 eyewitnesses, that is PW1, PW6 and PW7, that knife was the weapon of offense. But in the first information report, it is mentioned that Bhujali was used for causing assault to the deceased. The Land Council further argued that the names of the eyewitnesses are not there in the first information report. And therefore, there is every possibility that those three witnesses, eyewitnesses, those three witnesses have been subsequently brought on record to depose against the appellant as eyewitnesses to the occurrence. And therefore, once the evidence of the eyewitnesses are discarded, the other materials available on record are not sufficient to establish the guilt of the appellant. While concluding the argument, Mr. Chand submitted that the occurrence in question took place on 16/10/1999. And in the meantime, 24 years have already passed, or almost 24 years have passed. And the appellant is now aged about more than 65 years of age. And he has remained in custody from 17/10/1999 till he was granted bail by this court in criminal appeal on 19/11/2003. And therefore, he has for more than 4 years. And even if this court finds that the conviction of the appellant under Section 304 Part 2 is to be sustained, the sentence be reduced to period already undergone. Mr. Rajesh Tripathi, Learning Additional Standing Counsel, on the other hand, supported the impugned judgment and argued that the three eyewitnesses, are consistent, and they have specifically stated as to how the appellant caused stab wound on the abdomen of the deceased. And in the cross-examination, their evidence has not at all been shaken. The postmortem examination report, coupled with the evidence of the doctor, bracket PW9, clearly indicates that there was an incised wound on the left side abdomen, and the doctor has stated, after examining the weapon of offense which was seized from the possession of the appellant after he was caught red-handed at the spot, after he was apprehended at the spot, that the knife could cause such injury on the appellant. And
PW9 is the treating doctor and PW10 is the postmortem.
PW9 is the doctor, and PW10 is the doctor who conducted postmortem examination, also stated that the cause of death was due to
Page 51.
gram-negative septicemia, and the injury on the abdomen was antemortem in nature. In the cross-examination, he has stated that septicemia was caused by unsterilized surgical instrument. It is argued that since there is no infirmity or illegality in the impugned judgment, the criminal appeal should be dismissed. Adverting to the contention raised by the land council for the respective parties and analyzing the evidence of the two doctors, that is PW9 and PW10, it appears that PW9 were the surgery specialist attached to Headquarters Hospital, Keonjhar, examined the deceased on 18/10/1999 and found the following injuries, for the injuries, and he also examined the weapon of offense, and he further stated that the deceased was admitted after surgery to the hospital as indoor patient and was under treatment till 20/10/1999 when he died at 5:15 a.m. Red ticket. The doctor bracketed PW10 who conducted postmortem examination has also noticed the following injuries: external injury or internal injury. Quote kar देगा. The London Council for the appellant has not challenged the homicidal death of the deceased. After going through the inquest report, the evidence of the two doctors, the postmortem report, I am of the humble view that the London trial court has rightly came to the conclusion that the deceased met with a homicidal death. Now coming to the evidence of the three eyewitnesses, it appears that all of them have stated that it is the appellant who stabbed the deceased with a knife on the left side abdomen, and for which the deceased sustained injury, and he was shifted to hospital. Though all the three witnesses have been cross-examined at length, but nothing has been elicited in the cross-examination to disbelieve their evidence. The evidence on record further indicates that the appellant was apprehended at the spot and knife was seized from his possession. The knife was examined by the doctor bracketed PW9 and who has opined that injury on the deceased could be caused by such weapon. Therefore, not only the evidence of the eyewitnesses, but also the other corroborating evidence coupled with the evidence of the doctors it is proved that it is the appellant who is the who has caused the stab wound on the deceased on his left side abdomen, which ultimately resulted in his death. Merely because in the first information report, PW2, who is a post-occurrence witness, has stated that the bhujali was used for stabbing the deceased, the same cannot be a ground to disbelieve the prosecution case and to come to the conclusion that PW1, 6 and 7 are deposing falsehood that with knife the deceased was assaulted. Similarly, the absence of names of the 3 eyewitnesses in the first information report cannot be a ground to disbelieve the prosecution case. Taking into account the surrounding circumstances under which the occurrence has taken place and the fact that a single blow has been dealt on the deceased, which ultimately proved fatal, and the deceased died about 3 days after the occurrence, the London Trial Court rightly held the case to be won under Section 304, Part 2 of the Indian Penal Code. The occurrence in question took place on 16/10/1999, and the appellant was taken into judicial custody on 17/10/1999, and he was never granted bail during trial. And after he filed this appeal, he was granted bail by this court as per order dated 19/11/2003. And as such, it appears that the appellant has remained in judicial custody for more than 4 years and 1 month. Taking into account that 24 years have already passed in the meantime, and the appellant is now aged about 65, more than 65 years, and is on bail since 2003, November. I reduce the sentence to period already undergone. Accordingly, with the above modification of the sentence, the criminal appeal is dismissed.
Okay.